Well, maybe you get the names.
Certainly, everyone can be seated, please identify yourself. Let's do it this way. Court calls the case of cause number 2018-2573, case Quinn versus Montana Max Good Time Saloon, or whatever the official name of the entity is. Counsel, please make your appearances for the record.
Yes, Your Honor. Good afternoon. My name is Gunnar Osteen. That's G-U-N-N-A-R-O-S-T-E-E-N. And I, alongside my co-counsel,
George Buckley, G-E-O-R-G-E, and then Buckley is B as in boy, U-C-K-L-E-Y.
we represent the plaintiff in today's case, Quinn Chase.
Okay, defense counsel.
Good afternoon, my name is Hannah Pipes, P-I-P-E-S, alongside the counsel.
Good afternoon, Your Honor. My name is Blanche Dutu. That's N, D as in dog, O-U, C as in taxi, O-U for the defense.
So we are constructively outside the presence of the jury. Are there any housekeeping matters we need to take up?
Yes, Your Honor. A couple of housekeeping matters from the plaintiff as well as a few motions.
Start with housekeeping.
Yes, Your Honor. Firstly, we asked your preferences regarding moving about the well, approaching opposing counsel, the bench, and the witness statement.
As to approach the witness, as to approach the bench, otherwise you have free use of the well for examinations as well as opening place.
Yes, Your Honor. And we ask that all witnesses be pre-sworn and all exhibits pre-marked.
Done.
And with that, Your Honor, we're ready to move motions and limiting after any housekeeping from the defense.
Defense have any housekeeping?
Yes, Your Honor, we have one quick housekeeping matter. We will be reading deposition testimony from Al Overton, who's even not be present for today's trial. We're asking permission to read that testimony in the form of question and answer. So co-counsel taking the witness stand. Is that something the court would allow?
Yes.
That concludes our housekeeping. We have a motion eliminating two parts.
All right, we'll start with the plaintiff's commission moving first.
Yes, Your Honor. As the court is aware, we're here because the defendant's bar overserved a man named Al Overton. And as a result, he got into his car and rammed it into our plaintiff, Quinn Chase. Now, pursuant to that, there are a couple of admitted exhibits that we both agreed to pre-admit if you want me to give those to you.
Yes, what are they?
They are due to exhibits D, E, and exhibit 8.
D is in dog.
D as in dog, E as in echo, and then 8. The
Number 8.
Yes.
Okay.
Yes, Your Honor, the numbering system is a little weird, but pursuant to that, we have a motion limiting in 2 parts,
All right.
both of which have been agreed by the defense.
Great. Just someone up there.
Yes, Your Honor. The first is that there will be no mention of any medical insurance providing for the health care of Ms. Quinn Chase after the accident.
Okay.
And then the second is there will be no reference to a Steelton Liquor Commissioner's investigation done at the defendant's bar that found nothing.
Okay. Great. Correct. Am I correct, Ms. Pipes and Tito? Are those agreed upon?
Just yes, Your Honor.
All right. Defense, do you have any? You said you had M House?
Yes, Your Honor, I have a motion eliminating in 2 parts. So, Your Honor, this is the case where a young man went to the Montana Maxis for his 21st birthday. While there, his friends made him agitated. The plaintiff here today is trying to confuse signs of agitation for signs of visible intoxication. That brings me to my first motion in eliminate part 1. We anticipate the plaintiff may elicit testimony from any witness, but especially Quinn Chase about Montana Max's reputation for over-serving its patrons. Now, under Rule 401A1, this would be improper character evidence. It would go to the propensity of the bar to overserve its people then, and they're claiming that they are overserving now in this proceeding.
Response?
There will be no mention of a propensity to overserve. The only sort of reputation we will be getting into is that the plaintiff or the defendant's bar was known to be a bit rowdy and a bit rambunctious at times. That's it.
Court's going to deny them. What else?
Yes, Your Honor. For our second portion of the motion eliminate, we're concerned here today that the plaintiff may try and make an argument that the policies that Montana Max had in place equate to breaking the law of Steelton. We're simply asking that the plaintiff not allude or tell the jury the fact that because these policies were broken, that means the law was violated and Mr. Max Jr. was negligent.
Response?
Yes.
We won't be saying those policies that are in place are in fact the law of Steelton. However, they do go to the general theory of negligence. We have alleged against the defendants that because they couldn't even follow their own policies, they're negligent for the injuries that occurred in this chase.
Court's going to deny that commission. What else?
Yes, Your Honor. That concludes our motion eliminate. We're ready to proceed.
All right, we're ready to proceed to everything.
Yes, Your Honor.
We have constructively brought the jury in. There's counsel whenever you're ready to proceed.
into this court. Give me your keys. 4 words. 4 simple words that could have stopped Miss Quinn Chase from suffering 4 horrible injuries. When she broke her femur, she broke her collarbone, when she suffered a closed head injury, she ruptured her spleen, making her go the rest of her life worrying about the next time she gets sick because it weakens her immune system. This is a case about an irresponsible bar, about the defendant's bar, Montana Max's Good Time Saloon. Now, before I get into the facts, let me just go ahead and say, my name is George Buckley. This is my co-counsel, Gunnar Austin, and we have the distinct pleasure of representing Miss Quinn Chase, who I just said was involved in a car wreck. A car wreck because Al Overton was overserved at the defendant's bar. He was then kicked out of the bar, got into his car, and hit Miss Quinn Chase. So let's start from the beginning. What happened on that day? It was the day of January the 7th. This story goes on until the night and the early morning of January the 8th. But Miss Quinn Chase woke up to an exciting day, a day where she got to spend time with friends, a day where she got to have a date later that night. And when she got in her car to drive to that date, which was at Montana Max's, she was hit as she proceeded through a green light because the person that hit her started out his night in Montana Max's, Al Overton. See, January 7th was also an exciting day for Al Overton. It was his birthday as the night went from January 7th to January 8th at midnight. He was turning 21, and he got to exercise a legal right to drink alcohol. But as soon as he turns 21, the defendant's bar decided that it would be a good idea to sell him shot after shot after shot. A shot until he vomited. A shot when he knocked over tables and chairs. A shot Eventually, they decided it would be better to get this Al Overton out of their bar rather than leave him inside. Let's go ahead and throw him out to the public. So they did. And as he walked out to Max Petunia, he held up his keys and said, "See you later, suckers." So they let him go. So today you're going to get to hear from Miss Chase. You're going to get to hear about her injuries. You're going to hear from Max Petunia, who, though they try to explain to you that all of their policies were followed, will show you that he saw those signs of physical intoxication. You're going to hear from some experts as well. You're going to hear from experts who know what happened on the night, but in all reality, they weren't there. And at the end of the day, you will have the ability to decide by a preponderance of the evidence whether the defendant's bar is negligent. Let me break that down. A preponderance of the evidence simply means, is it more likely than not the bar was negligent? When you take the evidence presented to you by me and Mr. Osteen, is it more likely that they were the irresponsible party that did 3 things? And this is negligence. Did they have a duty? Did they breach that duty? And did that breach cause the injury to Ms. Chase? No one is arguing that the defendant's bar has a legal duty. When you sell alcohol, you assume a duty to act as a responsible bar owner. And they breached that duty because the evidence will tell you, as you will hear from Max Petunia, they witnessed the visible signs of intoxication. They allowed their untrained shop girls, or mischievous girls as they call them, to continue serving alcohol to Al Overton. They saw it all, and they did nothing. And that breach That breach is why Miss Chase has to sit here today. That breach is why she broke her femur. She broke her collarbone, and she suffered a closed head injury. Now, the defendants are going to come up here, and they're going to explain to you that we are suing the wrong person. They're going to explain that the only person to blame is Al Overton. They'll try to say that Al Overton drank in his car after being kicked out of that bar. But ladies and gentlemen of the jury, as we start to see the evidence unfold, as you hear the witness testimony, there's no reason for us to believe that Al Overton did that. The alcohol in his system was fueled and pumped into him by Montana Max's Good Times Saloon. So at the end of this, you will have the opportunity to make Miss Chase whole again. And more so than that, you will have an opportunity to make sure that no bar in Steelton engages in irresponsible practices like this. You will have an opportunity to make this town safer.
All right, that's council.
May it please the court. Agitated. Not visibly intoxicated. Mr. Overton was agitated at Montana Max's the late night, January 7th, into the early morning hours, January 8th, 2022. The blame here today has been misplaced. Now, of course, in some situations, the law does allow a third party to be held accountable, to be held liable for an accident that they weren't even present for. Notice I said in some cases. This is not a case today. Now, the judge will instruct you on what the law is at a later point in time. But for now, put simply, a third party, like a restaurant, can be held liable for damages if they serve a customer alcohol when they're visibly intoxicated. Not just intoxicated, visibly intoxicated. Those two words are going to be so important today. And I'm sure everyone in this courtroom are going to say those two words a lot. And they're very important because everyone at this table has the burden today. The burden is over here. They have to prove to you by a preponderance of the evidence that Mr. Overton was visibly intoxicated at Montana Max's. They also have to prove to you that despite being visibly intoxicated, the employees at Montana Max continue to serve him. And yet they also have to prove to you that Mr. Overton being visibly intoxicated, being continuously served drinks, the reason that Ms. Quinn Chase was injured in that accident. It's the reason the accident occurred. Albeit an unfortunate accident. It will become clear to you very soon here that Mr. Overton was agitated, not visibly intoxicated while at Montana Max's. And because he was agitated, the employees had no reason to intervene. But of course, you don't have to take my word for it. Because you'll hear testimony from Mr. Al Overton himself. Now, I will tell you now, he won't take this witness stand. He cannot be physically present today. But co-counsel and I will read his exact words, his words. And you'll learn from his testimony about what happened. You'll learn that around 10:30 p.m. on January 7th, 2022, Mr. Overton arrives at Montana Max's, completely sober. You'll learn that he didn't have a drink until after midnight, because after all, it was his 21st birthday. You'll also learn that around 2:30 p.m. is when the unfortunate accident occurred. And in between Mr. Overton arriving at Montana Max's and the accident, you'll hear things like Mr. Overton threw up, Mr. Overton spilled a tray of drinks in a crowded bar, even got into an altercation with his friends. And you'll learn that Mr. Overton was honest when he gave his deposition. He's going to be honest, and you're going to learn that he did have 4 to 5 shots, which of course you'll learn later were watered down. He also had a beer. He's going to be honest about that. Now, we anticipate the plaintiff may call Ms. Quinn Chase to the stand. And if that happens, Ms. Chase will have to sit there and admit to you that on the night of the accident, she was also drinking. She was actually throwing a huge party, 75 plus people. The alcohol was coming and going. She'll also have to admit to you that she had 4, 5, 6 beers. She'll say that she also tried some real fancy scotch. And after all those drinks, she decided to get in the car. She decided to get in the car, turn the car on, start driving down Main Street. She'll also be forced to tell you that she was on the phone when this accident occurred. Now we're also going to call Mr. Petunia, Max Petunia. And Max Petunia is the owner of Montana Max's. And he's going to get on that stand and he's going to talk to you. He's going to tell you he's been in the industry for 15 years. He's going to tell you that he takes the service of alcohol seriously. So seriously that he's crafted a set of policies and procedures to guide his employees. To guide his employees on how to look for signs of a visibly intoxicated customer. His employees know through these policies and procedures how to keep track of how many drinks a customer has. Maybe print a receipt every now and then. There's even rules that certain employees cannot serve multiple drinks to one customer. And when he takes that stand, it's going to be very important because he's going to talk all about these policies and procedures. And he'll tell you that also within those, there's a procedure for a visibly intoxicated person. And that procedure is to get them some water, get them some food. Call a ride for them. Don't let them drive. But there's also a proper procedure for how to deal with agitated customers. And that procedure you'll learn is to get them out of Montana Max's as soon as possible. Towards the end of today, you will hear from Dr. Malkin. Now, Dr. Malkin is an expert in his field. And he's going to wrap everything up for you. Point blank, he's going to sit there and he's going to tell you that Montana Max acted reasonably January 7th and 8th. He's going to tell you that they had the proper procedures and protocols in place. He'll also tell you that Mr. Overton was agitated, not visibly intoxicated. Now we anticipate Mr. Overton's behavior in Montana Max's, specifically him throwing up, the spilling of the tray of drinks, getting into an altercation with his friends. We anticipate the plaintiff will take these and say, well, those are visible signs of intoxication. But ladies and gentlemen of the jury, I want you to remember, no one who sits in that chair right there and testifies today can tell you exactly what time Mr. Overton threw up. No one can sit there and tell you exactly what time this altercation happened between his friends. No one can tell you what time a tray of drinks was knocked over. For all we know, he could throw up after his first shot. He could have had the altercation right from the beginning, maybe out the door. We don't know, and no one can tell you that. Members of the jury, the dispute today is about Montana Max's involvement in the accident between Miss Quinn Chase and Al Overton. Mr. Petunia is not liable just because Mr. Overton decided to go to Montana Max's that night before the accident. That doesn't make Mr. Petunia liable? Mr. Petunia wouldn't even be liable if Mr. Overton was intoxicated at the time of the wreck. If Mr. Overton was visibly intoxicated at the time of the wreck. What we're here today about is Mr. Overton when he was at Montana Max's. And while he was there, he was agitated. Because all Mr. Overton was agitated, at the end of this trial, you'll have to find Mr. Petunia not liable. Because not liable will be the only verdict that the evidence supports that justice will demand.
Thank you so much. Plaintiff, you ready to call your first witness?
Yes, Your Honor. For our first witness, the plaintiff calls Quinn Chase. Good afternoon, Ms. Chase.
Good afternoon.
Could you just introduce yourself to the jury for us
Hi, my name is Quinn Chase.
and tell them a little bit about yourself?
Well, right now I am a graduate student at Springs Training University. I'm currently majoring in sports management. I hope to go on and work in the NCAA, hopefully represent some pro athletes at some point.
So you're in graduate school. What did it take to get there?
Well, I did do an undergraduate degree. I did that at Steelton State University, and that was your standard 4-year undergraduate. And then, there's the applications to get into graduate school, things like that. So a little bit of a process.
We'll get into more of the accident in a moment, but did this car crash that you were involved in hinder your plans for graduate school?
Yes, it did. So the accident occurred in January of 2022. I was a junior at the time at Steelton, and it was January, so the spring semester was just about to start. And because of the accident, I ended up taking the rest of that semester off. And so it delayed me finishing up my junior year.
Do you feel impacts of it today as you're studying?
Yes, I mean, I had to kind of rush to get through my undergraduate. I had to catch up by taking summer classes, and those were remote too, which is not the most ideal type of class form to have to take. So it definitely had an impact.
And now we'll get into more about how you are today here in a little bit, but let's go back to January 7th. What was the plan for that day? Had Al Overton not crashed into you?
Well, that day there was a big game going on. So my roommate Shane and I, we were going to have a party at our place, have people over to watch the game. And then I also had a date later that night.
What time was the date for?
It was kind of late. It was at like 2 a.m. But that was the time that I could make work that night.
So you said you had a party. How many people were there?
Like 75, give or take, but people were like coming and going all day. So that's like an estimate.
And you think college party, you think alcohol. Was there any drinking going on?
Yes, we had a keg at our place, but that was like the only alcohol we supplied. People brought some of their own stuff if they wanted to.
So were you drinking?
I was.
How much did you drink?
Well, we tapped the keg at about 7, so I probably had my first beer around then. I had maybe 4 or 5, and then someone brought some scotch, and I sipped on a shot of that for a little while.
So in total, how many drinks would you say you had?
Between 5 or 6, probably.
And you said you started at 7 when you stopped.
I think it was around midnight.
So how long were you drinking?
Probably about 5 hours or so.
So then what happened at midnight?
Well, I stopped drinking because I had my date later. So, and after midnight and the party was kind of winding down, I got ready to go to my date.
And how did you get there?
I drove.
So I have to ask, because I know you heard opening statements from the defense. Were you drunk?
No, I was not drunk.
Were you intoxicated?
No,
Have you ever driven intoxicated?
no, I haven't.
So what road were you taking to get to where you were going?
The main road through Steelton, I think it's called like Road 60 or something, but it's like the main stretch through town.
And I forgot to ask, where were you going?
I was going to Montana Max's that night.
So do you think, just to get an idea of the car crash and where it happened, Do you think that it would aid the jury in understanding this if you were to help me create a demonstrative?
Yes, I think that would be helpful.
Your Honor, at this time, I'd ask the witness to step down in order to help me to create the demonstrative.
And counsel, we need to position yourself.
So Ms. Chase, again, I know this is a scary time and thing to remember, but could you start by just showing me the road that you were driving down?
Yeah, absolutely. So the road that I was driving on was Road 60. Sorry, seems like we have. Yes, I got it, but I can use this one. Okay, so the main road that I was on, it was Road 60. So that was kind of just a straight road. So I'm drawing 2 lines down the middle to show that road.
And could you just show me the direction you were driving? Use an arrow or something like that.
Yeah, so I was driving, if this is in front of me on this diagram, I was driving straight up this way. So I'm drawing an arrow from the bottom up towards the top of the paper.
Okay, and where did Al Overton come from?
Al Overton, as I was driving, he came from my right-hand side, from a road that was in between some parking lots.
Okay, could you show that road?
Yeah, absolutely. So I'm drawing 2 perpendicular lines kind of on the middle right-hand side for that crossroad that Al Overton was on.
Okay, and you said that you were heading to Montana Max's. Was it close?
Yes, it was pretty close.
Would you be able to see it on this map that you're drawing, kind of?
Yes, you would. It was actually like, it would be like kind of in this right top-hand corner up here. So I'll draw a box up there. That's where Max's was.
Okay, could you label that Max's for me?
Absolutely. So this is Max's right up here.
And what is this space in between Max's and this crossroad?
This would be one of the parking lots next to Max's.
Okay, could you label that for me?
Sure. I'm gonna write PL for parking lot.
Now, I know you're familiar with this place. Is that Max's parking lot?
I believe so. I mean, it's right next to Max's, so it's the parking lot next to Max's.
Okay, so we'll move a little bit kind of closer onto the actual car crash. Show me where your car is on here.
I was kind of driving through this intersection right here. So my car was kind of next to that crossroad.
Okay, and could you show kind of, well, you showed me the direction already. Was there a light or a stop sign or a yield or what was that?
There was a stoplight. That's a 3-way intersection, and it had a stoplight to my left and a stoplight right in front of me.
Could you show that on here?
Sure, I can draw 3 circles, kind of as my car is going through them, in the middle of that road for the stoplight.
And did this road over here have anything to indicate them that they needed to stop?
Yes, there was a stoplight on the left-hand side of the intersection.
Could you show that too?
Sure, so that stoplight would be right in front of that crossroad. So I'll draw 3 circles for that stoplight.
What color was your light?
My light was green.
Could you show that with that green Sharpie behind you?
Sure. So I had a green light. So I'm drawing, coloring in those circles I drew. Those were green.
And I guess that would mean that Al Overton's light was red. Is that true?
If my light was green, I'm pretty sure his was red.
Could you show where Al Overton's car was?
Sure, so his car was coming out on this road right here. So I'll draw his car coming out from that road.
And could you draw an X where he ended up hitting?
Yeah, absolutely. So Al Overton hit me on the passenger side of my car. So I'll draw an X in the like lower right-hand side. That's where the impact was of the accident.
Well, thank you so much for this, Ms. Chase. I feel like this is helpful. At this time, you can return to the stand. So were you swerving when you were driving?
No, I was just driving in a straight line.
Was it raining?
No, it wasn't raining.
Were your headlights on?
Yeah, it was nighttime, so my headlights were on.
And I know you already said it, but was your light green?
Yes, my light was green that night.
Were you doing anything wrong?
I didn't think so. I mean, I was proceeding through the intersection. My light was green. I was just driving straight ahead.
Were you, was there anything that could have been distracting you?
No, I didn't think so. I mean, my eyes were on the road. So I didn't think I was distracted that night.
Were you doing anything at the time you were hit?
I was, my date had actually called me, but I Bluetooth in my car, so, I took the phone call, so I was on the phone at the time.
Did you have your like hand up to your ear?
And no, I have Bluetooth, so you don't have to do that with Bluetooth.
So let's talk about when Al actually hit you. What did that feel like?
Well, it was really jarring. I obviously I wasn't expecting it, so I just remember the force of the impact, and the car hitting the passenger side and just being like flung forward in my car, and hitting my head and hitting my stomach, feeling my collarbone break. So it was just a very all-encompassing moment when that happened.
Did you hear any noises?
Yeah, I mean, when metal hits metal, it's not exactly quiet. So, I can remember the screeching of, the metal hitting the metal. And it was loud.
And tell me again, what all parts of your body were hurting?
So I hit my head on the driver's side door. And then I think from the force of the car hitting me, it kind of flung me forward into the steering wheel. So I hit my stomach area. And then I felt my collarbone snap on my left-hand side. And then my leg was in a lot of pain, and I later found out that I had broken it.
Did you lose consciousness?
My memories are a little fuzzy from the time of the accident. I don't think I fully blacked out. So I don't think I became fully unconscious.
And where did you go next?
I was taken to the hospital.
Just by yourself?
Yes, I mean, I was driving alone that night, so they had to take me by myself to the hospital.
Were you scared?
Oh, absolutely. I mean, I was scared because the accident had happened and I wasn't expecting it. And then I was scared because I was in so much pain. And I was scared because I didn't know what was exactly wrong with me yet.
And when you found out what was wrong with you, what is your understanding of your diagnosis?
Well, I ended up having a fractured collarbone on my left-hand side. I broke my left femur. And then I had a ruptured spleen as well.
And so I know school was starting soon after this, but were you able to go back?
At the time, I didn't think it was the best option for me to go back because of my injuries. I had to be put in a cast in a sling. And with the pain from my spleen, I just didn't think me trying to get to class was going to be the best option for me. So I took the rest of that. I took that.
In a cast or in a sling?
My leg was in a cast for about 4 to 5 weeks, and then I wore a sling for my collarbone for about a month.
How was what were your emotions like throughout the rest of that semester?
I mean, I was upset about not being able to go back to school that semester. And obviously I was trying to heal from the accident. So it was, trying to deal with the pain and then trying to figure out my future was stressful. So it wasn't a great time in my life.
And I meant to mention this earlier, but when you were at the hospital, what were your medical bills?
I think they ended up being about $75,000.
And then lastly, just now, how are you? What are the lasting impacts of this?
Well, it was a lot to have to go through all of the treatment and things like that after the accident. So, that was a difficult experience. And then with my spleen injury, my understanding is that I'm less capable of fighting infection or illness. So that's a big concern for me, wanting to go out and do things that normal graduate students do. There's the worry that I could get sick or get an infection, and I don't know when that can happen, how long it could last. So that's something that weighs on my mind.
Ms. Jace, I thank you for being here today and answering these questions. No further questions, Your Honor. I'll pass this.
Did you cross-examination?
Yes, sir. May I proceed?
Yeah.
Ms. Chase, when driving, it's important to remain alert at all times, correct?
Yes, it is.
It's important to avoid all possible distractions, yes?
Yes.
And before driving, it is important to limit alcohol use, correct?
Sure. Yes.
Now, I want to talk about the night of January 7, 2022. You hosted a party,
I did.
and that party started at around 10 p.m.
Yeah, from what I can remember, it was around 7. That's when we tapped the keg.
and there was alcohol.
There was. We only provided the keg.
And you drank some of the alcohol.
Yeah, I did.
You didn't only have 1 beer,
No, I didn't.
or 2 beers,
No.
or 3 beers.
No.
You had 4 to 5,
Yes, I did.
and some scotch.
Yes, I had a shot of scotch.
Now, you left your house at around 2 a.m., correct?
Yes, I did.
And you got in your car
Mhm.
and you started driving,
I
right?
did.
You didn't put your phone on Do Not Disturb.
No, I didn't. I didn't think I had a reason to.
So that's a yes to my question.
Yes.
Now, you testified on direct that you stopped drinking at around midnight.
Yes, I did.
Well, to be fair, you don't remember at exactly what time you stopped drinking, correct?
I know it was around midnight.
So that's a yes to my question.
I know it was around midnight.
So your testimony today is that you remember that it was at around midnight that you stopped drinking.
I think it was around midnight.
So it could have been after midnight.
Sure, it could have.
Now, as you were driving, your date Chris called you, right?
Yeah, he did.
And you answered the phone.
Yeah, I did.
You were talking to Chris
Yes, I was.
when the accident happened.
Yes, I was.
Now, you mentioned that you are familiar with the parking lot next to Montana Max's, correct?
Yes.
Have you ever testified differently?
But I'm familiar with the parking lot.
Yes.
I mean, what do you mean by familiar with the parking lot? That it exists or what
Well,
the
you can
layout?
say that you're familiar with the parking lot, yes?
I mean, I was driving past it at the time of the accident.
Is that a yes to my question?
Sure, yes, I know where the parking lot is.
And so have you ever testified differently to that?
I can't remember.
And so you can't tell us that you know that this parking lot belongs to Montana Max's, right?
I mean, there's not like a sign on it that says who the parking lot belongs to.
Right,
No.
so you don't know that it belongs to Montana Max's.
No, not necessarily.
So after the accident, you told the cop at the scene that you had been drinking, right?
I did, yes.
And he didn't give you a breathalyzer test.
No,
And you were brought to the hospital
yes, I was.
where you received treatment.
Yes, I did.
And you stayed there for less than a week.
I think it was about 5 to 6 days, yes.
So that's just less than a week, right?
Yes.
Now, Ms. Chase, no one's ever recommended that you would need future treatment, correct?
Not that I know of right now, no.
Relating to this accident, no one's recommended that you need future treatment.
No, not as of right now, no.
Now, you, correct me if I'm wrong, but you talked about having headaches, yes?
Yes,
All right. Now, you used to play hockey before this accident, yeah?
I did.
You stopped playing 1.5 years before this accident.
Yeah, I did. School got busy.
Well, when you were playing hockey, you got multiple concussions, right?
I think so, yeah.
And from those concussions, you had headaches.
Yes, occasionally, yeah.
And now you still have headaches.
I do.
Now you are right-handed, correct?
I am.
Your right arm wasn't hurt in the accident.
No, it wasn't.
So you testified that your left arm was hurt,
Yeah, my left collarbone.
but it wasn't limiting.
What do you mean by that?
Well, according to your testimony, although your left arm was hurt, it wasn't limiting, correct?
I mean, it was limiting on my left arm.
So it's your testimony today that your left arm was limiting.
I mean, my left arm was in a sling for a period of time.
So my question
My right
is,
arm was free.
so you're testifying today that limited you?
I mean, what do you mean by limited? In what way?
Well, how would you define it?
Well, I mean, some things became more difficult when your arm is in a sling, like, washing your hair, things like that. Like, that's a little bit more difficult than if I had both of my arms free.
Well, have you ever testified previously that your left arm didn't limit you?
I don't think so, no.
Okay. Do you remember giving a deposition for this case?
I do.
And you remember taking an oath before this deposition, correct?
I did.
The same oath that you took today,
Yes,
to tell the truth,
yes,
the whole truth,
yes,
nothing but the truth,
yes.
for the record and open counsel. I'm on page number 64. Page number 65. Page number 65, line 20. 20. Let's start at line 20 through about page number 66, line 4.
Your Honor, I'm objecting to improper impeachment. There's nothing in the lines that were mentioned by opposing counsel that would go against anything that my client has just said.
What exactly are you trying to get at?
So she just testified that her
Constructively or?
constructively. She just testified that her left arm limited her. But in her testimony, in her deposition, she says, limiting, not really, because I wasn't doing anything. I'm also right-handed, so it wasn't that big of a deal.
Chance to respond, Your Honor.
Yeah.
She didn't testify that her left arm was limited. She said that it limited movement of her left arm.
I'm gonna allow you to redirect. I may proceed with the examination.
So can I proceed with the?
Yes.
Okay. All right, so for the record, we are looking at page 65, starting on line 20 to page 66, line 1 through 4. May I approach the witness with the deposition?
May.
This is your deposition, correct? Ms.
Yes,
Chase?
yes, it is.
All right. Now, I want you to take a look at, once again, page 65, line 20. I'm going to read and I'll ask you if I'm reading it correctly and just yes or no, okay?
Okay.
All right, so question, what about your broken collarbone? Answer, they couldn't do much for the collarbone, but put my arm in a sling. The leg, they put it in a cast to reset it. Question, how long did you have the sling for? Page 66. Answer, about a month. They just wanted to make sure it healed okay and didn't move. Question, was it really limiting? Answer, limiting? Not really, because I wasn't doing anything. And I'm also right-handed, so it wasn't that big of a deal. Did I read that correctly?
Yes, you did.
Now, you took a semester of school, right?
I did.
This was your decision.
Yes, I thought it was best at the time.
You don't have a doctor's recommendation to take the semester off.
No, that wasn't something I think they were going to tell me.
So that's a yes to my question.
Yes,
And so you stayed home,
yes, I did. I was healing.
you played video games.
Yes,
But after that semester, you were able to go back to school.
yes, I made the choice to do summer school.
You graduated on time
I did.
and you went off to grad school.
I did.
No further questions.
All right, you ready?
Yes, just one question for you, Your Honor. Ms. Chase, earlier the defense counsel seemed to imply that you were lying about saying that your left arm was limiting. What did you mean when you said that?
I mean, I just meant that my arm was in a sling. So like when your arm is in a sling, you can't like raise your arm above your head. So that's what I thought. And that would be what I thought it was limiting.
Understandable. Your Honor, at this time, we have no further questions. We ask the witness to be dismissed.
All right, let me say. Like, dismiss her from the speech wants to sit in for this one.
Yes.
Identify next witness.
Yes, Your Honor. I'd like to call Sidney Crosby.
Right, it's cool. Sworn whenever you're ready to see this person.
Yes, Your Honor. Okay. Good afternoon. Would you mind introducing yourself to the jury?
Yeah, hi, my name is Sidney Crosby.
What do you do for work, Mr. Crosby?
So I am currently a general manager at a bar that's actually here in Steelton called Michigan Mike's.
Now, why are you here testifying today?
So I'm here because I came to an opinion about the policies and procedures at Max's bar and whether or not Mr. Overton displayed visible signs of intoxication.
Well, before we get to that conclusion, I want the jury to get the chance to get to know you a little bit better. Did you go to school?
Yeah, so I went to school right here in Steelton and I got a BA in hospitality and hotel management.
Earlier while we were talking, you mentioned that you work in a bar. How long have you been working in bars for?
So at this point, I've been working in bars for about 7 years.
Now, do you have any relevant certifications for running a bar?
Yes, so I'm actually a certified instructor in something called STOP. And basically it stands for C times to oppose problems. It's kind of clunky, but essentially it helps you identify visibly intoxicated people.
Now, is STOP a standard method within your field to identify visibly intoxicated people?
Yes, it is.
And was that the method that the defendant's bar used?
No, they used a different method in some cases called TIPS.
Now, have you ever taught any classes on STOP or been published on STOP before?
Yes, both. So I've taught many classes on STOP at this point, being an instructor, and I've been writing articles on it for about 8 years.
Now that we've talked a little bit more about you, let's talk about what you did. Now, what did you review when coming to your conclusions in this case?
Yeah, so obviously I wasn't at the bar that night, but I got to review all of the depositions from witnesses that were there and also some exhibits that helped explain the picture of what happened that night.
Is that what you normally do when called to testify in cases like this?
Yes.
And did you sufficiently apply your method to the facts and data, in this case, those depositions and exhibits you talked about?
Yes, I did.
So when you did all that, what was your conclusion regarding the practices at Max's bar?
Yeah, so I break my conclusion into 3 parts really. So first is that the procedures, they weren't followed that night. Second is that the training was insufficient at Max's. And third is that they failed to identify a visibly intoxicated person.
I want to break that down into pieces for the jury. Now, I wanted them to have a very good idea of what Mr. Overton did at the defendant's bar that night. Do you think it'd be helpful to construct a bit of a timeline to walk them through the events of what happened?
Yes, I think that would be very helpful.
Your Honor, permission for the witness to step down and to make use of demonstrative.
Amen.
If you could join me over here, Mr. Crosby, I'll bring this closer. And you can grab that black Sharpie there. We'll use that. So if you could go ahead and draw a timeline for me.
Yeah, I'll
Excuse
just
me, Your Honor. May I read this?
Absolutely.
draw a line here across the page and we'll put arrows for time on the ends.
So what time did Mr. Al Overton arrive at the defendant's bar that night?
Yeah, so Mr. Overton got there at 10:30 p.m. So just mark that here. 10:30 p.m. Mr. Overton arrives.
Now, do you happen to know why Mr. Overton chose the defendant's bar that night?
So Mr. Overton and his friends were actually going to celebrate his 21st birthday that night. So that's why they were there.
They plan on doing anything special to celebrate?
Yeah, so when they came in at 10:30, they were all boasting about a plan to take 21 shots that night, one for each year of his life.
Well, what time did Mr. Overton start drinking?
He didn't start drinking until midnight because his birthday was January 8th, the following day.
So can we go ahead and put that on the timeline?
Down here, just writing 12 a.m. Mr. Overton.
You can squat.
I'll do my best.
I appreciate it.
Drinking.
Thank you, Mr. Crosby. Now, who was serving the defendant that night, or Mr. Overton?
Yeah, so Mr. Overton was getting his alcohol from what they call the shot girls there, or the mischievous girls. It's basically people that walk around with these trays of shots.
Now, I want to stop and talk about these mischievous girls for a second. Now, does the defendant have policies and procedures to train their regular employees?
They do have procedures for the regular employees, but these mischievous girls are different.
How are they different?
Well, they are typically, overturned frequently in the industry, so they actually will have untrained shop girls just walking around on the floor.
Well, hold on. Mr. Crosby, did the defendant have untrained shop girls on the floor that night when Mr. Overton was there?
Yes, he did.
Were those the same servers serving him those shots?
Yes.
Well, how many shots was he served?
So Mr. Overton, from reviewing his deposition testimony, he was taking about one shot every 15 minutes. And he was there until around 1:30 to 2 a.m. So that would be between 6 and 8 shots.
Well, can we indicate that on the timeline then?
Yeah. At the end here, I'll just put 1:30-2 a.m. And this is technically when Mr. Overton leaves. So Mr. Overton leaves. And I'm just going to indicate, kind of wrote pretty big here, but just put some dashes here to indicate that time. And going to write drink 6-8 shots, or between 6 and 8 shots.
Thank you, Mr. Crosby. You can go ahead and take your seat. Now, I want to talk about what the defendant did during that timeline from when he started drinking to when he left. Now, was the defendant or was Mr. Overton just sitting there drinking at his table?
No, he was not. He was, roaming around the bar, and he got into a bit of trouble while he was there.
What do you mean by trouble?
So Mr. Overton, it's not exactly clear what happened. There was an incident where he was blamed for, touching one of these shot girls, and then a fight started between him and his friends.
Did Mr. Overton display any other signs that you found could have been concerning?
Yeah, so, those changes of behavior are very concerning for being visibly intoxicated, but he was also stumbling around and he knocked over a tray of drinks. He vomited. That's a big sign of being intoxicated. So,
Have you been in trial today?
yes, I have.
Were you here when the defense came up here and said something about agitation, not visible intoxication?
Yeah, I heard that quite a bit, and by reviewing the evidence, that's just not what this shows. Mr. Overton consumed a lot of alcohol, and I don't think being agitated makes you vomit.
I want to move on and talk about the policies and procedures you felt the defendants didn't adhere to. Could you explain what you meant by that?
Yeah, so Maxis has lots of policies and procedures about identifying these visibly intoxicated people or VIPs. And, you know, the things that we've talked about of fighting, vomiting, you know, changes in behavior, like getting loud, that is all indicated as things that show someone's visibly intoxicated.
What should you do when you see that someone's visibly intoxicated?
Yeah, so, you know, per their own procedures, you're supposed to intervene. You can do things like offer someone a drink of water, offer them food, you know, of course, make sure they're not served any more alcohol, and absolutely don't let them leave if you can avoid it.
Well, why shouldn't you let them leave?
Well, I mean, if someone's intoxicated, you know, to the point where it's this obvious, they could easily leave, get in a car, and either hurt themselves or someone else seriously.
Was there any way to know that Al Overton was planning on driving that night?
Yeah, I mean, you know, after this fight happened, he started getting in an argument with the bouncer. They kicked him out, and right before he left, he took out his keys and said, "See you later, suckers."
What should the defendants have done at that point?
You know, at that point, you gotta stop him, or I mean, at least ask him some questions, call the police, I mean, anything.
Did they do that?
No.
Thank you, Mr. Crosby. No further questions.
Cross, Ms. Pipes?
May I proceed?
May.
Hi, Mr. Crosby. Now, you were here today on behalf of the plaintiff, right?
That's correct.
You were hired by the plaintiff,
Yes, I was.
you getting paid by the plaintiff.
Yep, it's my job.
So you're here doing what the plaintiff wants you to do, right?
I'm here to testify from what I saw.
Right, you're here to give your opinion, correct?
That's correct.
Your opinion on something that Mr. Max Petunia is involved in?
That's correct.
And you know Mr. Petunia.
I haven't talked to him or anything.
But you know he owns Max's, Montana Max's, correct?
I am aware of that, yes.
And you actually work at Michigan Mike's, right?
Right, it's the bar right next to Max's, yeah.
And you're not just an employee there, you're a general manager, correct?
That's correct.
So it's fair to say that you're competing with Montana Max when you leave here today.
I mean, as a general manager, not exactly competing, but the bars are in competition, if that's what you mean.
Right, because you both serve alcohol.
Right,
Food from time to time you may serve, right?
that's correct.
You're located in the same college town, so to speak.
Yeah,
So a lot of your customers are the same demographic.
I mean, I'm sure some people prefer one place over the others, but if people like to drink, they might end up at one of our bars.
Right, and you want people to prefer your bar, correct?
I mean, as long as I have my job, I'm doing all right.
Now, Mr. Crosby, I actually do want to mention this demonstrative that you just made. I want to talk about it for a quick second. Now, you wrote a lot, right?
A few things, yeah.
Right, but there's an hour and a half. You don't know what happened, right?
I mean, I know that Mr. Overton was in the bar.
Well, you can't tell me what happened in between 10:30 and 12 a.m., right? You can't give me a time.
I know what you mean by a time.
Right, so you were here in court all day, correct?
That's correct.
So you're well aware that Mr. Overton got into some sort of altercation with his friends?
That's correct.
You're well aware that he vomited while at Montana Max's,
That's right.
and you're well aware that a tray of drinks was spilled.
That's correct.
Right, now, you can't tell me exactly what time to the minute Mr. Overton threw up. You can't add this to that chart.
I can tell you it was after he had a drink.
I appreciate that, but that wasn't my question. You can't come up here and write to the minute what time he threw up.
To
correct?
the minute, no.
And you also can't do the same about the altercation with his friends,
To the minute, I cannot say.
right? And this is just a yes or no. And you also can't tell me to the minute what time you knocked over the tray of drinks.
That's correct.
So let's focus on what you can tell members of the jury. You can tell me that Mr. Overton arrived to Montana Max's around 10:30 p.m., right?
That's right.
And you can tell me that the accident occurred sometime around 2:30 p.m. Is that fair to say?
But the accident occurred at 2:30 p.m.
Yes. Is it fair to say that the accident between Ms. Quinn Chase and Mr. Overton occurred somewhere between or around 2:30 a.m.?
Yeah, I think it was around there. Yeah, shortly after he left.
So it's a yes to my question. You can say it was around that time.
Yeah,
So you can tell me those times, but you can't tell me what was in those shots that was served to Mr. Overton, right?
it was liquor.
Right, but you can't tell me what liquor.
I'm not sure what the shot girls carry around.
You can't tell members of the jury the brand of liquor.
I can't tell you that.
You can't tell the jury any additives they may have put into the shots.
I don't know if Max's puts anything else in their shots.
I want to talk about these indications you were mentioning on the red earlier. And you said throwing up is or could be a sign of a visibly intoxicated person. Am I getting that right?
Yes, that is a sign.
And you also said that this altercation between his friends, that could be another sign.
That's correct.
And then again, with the tray of drinks, that played a part in your conclusion today, right?
That's correct.
You'd agree with me that all three of those things can happen to an agitated person?
Right, what do you mean by can happen to it?
Right, someone who's agitated could throw up, yes or no?
Anyone can throw up, yes.
So is that a yes to my question?
Yes,
Anyone who's agitated in a crowded bar can knock over a tray of drinks, correct?
sure, but Mr. Overton stumbled.
Right. Anyone who's agitated surely probably gets in fights with his friends, right? Just a yes or no.
I'd say no to that.
Just to be clear, Mr. Crosby, you had to read over some depositions to prepare for today,
That's correct.
and because you weren't there that night, January 7th or 8th at Montana Max's, correct?
Right, I was not present.
Yeah, so you're depending on the words of another, correct?
Depending on all the evidence we have for this trial.
Right, and part of the evidence you reviewed is testimony, right?
Right, like I'm giving now.
But you relied on testimony in the form of a deposition, correct?
That's correct.
And that's what you relied on, the words of others.
The sworn testimony of someone else, yes.
That's the witness round.
All right, is there any redirect?
No redirect, Your Honor, we just asked this witness.
All right, later, clients with this.
Your Honor, at this time, the plaintiff has no more witnesses to call. We rest to close our case in chief. We just ask for a brief 5-minute recess before we begin the defense's case.
The only man for defense both have that.
Why don't we take a recess and we'll take a back to March? Let's take a break. Wait for like, just keep like closer to 5.
Yeah, how long?
Like 5?
5? All right.
We have time for lunch. So leave it.
No, no, you're good.
Nobody.
Warm in here, right?
Somebody can tell us.
That's a defense lawyer. Yeah, height and.
It's Piper and, they want, they want days regarding you guys.
No.
No, it's this name, so we know how to address it formally. It's Ms. Pipes.
Yes. Stella?
Due to.
Due to,
Yeah.
could you spell that for me? Please? N
DOU.
N D O U
TOU.
T O U. Thank you, Ms. Newton.
Thank you.
All right.
Yeah, I
It's
was
N
like,
D O U. T
TOU.
O U. I was gonna get better. You need anything to listen?
How many copies?
How are you, Judge?
Awesome.
I'm doing well.
So. That's what.
Are they allowed to use the,
The tech.
the media? Yeah.
So we were permitted to use the Elmo, so the projector. I think most people, I mean, I did not come across anyone that like made PowerPoint slides or stuff like that. And I think
But the Elmo, yes.
the Elmo, you probably would say that's what it's
Okay. Just wanted to know kind of like the ground
What the
rules.
options
Yeah,
are.
yeah.
I'm sorry, I didn't mean to like, I'm sorry, I don't know your name, sorry.
Judge Link.
Also,
I didn't mean to be like, oh yeah, like don't talk in front of them. I was like literally the round I was dressed in earlier today. Someone like commented about like, oh, someone did this well, and someone did that well. I'm like, no, I want their like opinion. I'm
I
like,
was
don't.
trying to get the stone in the ladies' night.
Yeah.
No, I've done like 50 of these.
Yeah.
sort of things.
We know not to deliberate.
Yeah, not to be, it was like not to be influenced.
Yeah, but
by
I think
language
we're, yeah,
words.
what we
Yeah.
were asked to do was not deliberate or anything, just give an independent opinion on paper.
Exactly,
That's it.
exactly, yeah.
It is
That's
what
how
it
we'll
is.
talk about it somewhere else.
Now we can, Sally?
Sally?
Yes.
Rick.
Hi, Rick.
Are you a judge or an attorney?
I'm an attorney.
Well, I guess judges are, excuse me. Are you a judge and an attorney or an attorney?
I'm planning on being a judge.
Oh, congrats.
No, I'm not,
Oh, you're
I'm
not.
not.
Well, congrats. Nonetheless. What kind of law do you practice?
Yeah.
Yeah, more plaintiffs or defense work?
Plaintiffs.
Okay, so I did plaintiffs for this case, it was a lot of fun.
I used to be a defense attorney.
When did you?
Money.
Okay. Wait, so like, no, actually,
Fulfillment
I have.
and money.
Yeah, because like I enjoy the plaintiff side so much more, but because with like all the PR work is just like, you're just splitting it into three, like it's, I feel like the plaintiff's defense, like I feel like they end up making more money.
Mm-mm.
No? Is it just
Not in my
like-
case.
Okay, so this baby's good.
No, I'm just making more money than
Be
ever.
a good attorney, it doesn't matter. All right, that is fair enough.
I'm very honest.
Fair enough. No, I mean, like, I'm enjoying it, I'm learning some stuff here, but we ended up time with them. So I'm like, oh, what would possibly we have done to be at the table right
Right.
now? But
No, I mean, I learned a lot doing defense,
yeah.
and that like sort of gives me an edge in what I do.
Of course, it sounds like it's kind of like clerking and then coming and being on the other side of it.
Let's put it this way, it would be more tantamount to like working at the IRS and then going to defend taxpayers against the
Do you kind of have like a niche for this DI work or
We-
you guys do everything?
I do a little bit of everything, but my preference is 18-wheeler accidents. because that's what I did. I defended a teenager
Yeah,
accident.
of course. And now you are.
I- Not as much as I'd like to. My biggest docket is sexual assault against Uber, Lyft. Uber and Lyft.
Oh, wow.
Yeah, I have over 100 of those cases.
That's.
Not taking Uber and a Lyft anytime soon.
I take Uber actually all the time. But you know,
Is what I'm hearing.
I don't know about Lyft. I've never had the Lyft app or anything, but if I'd be very concerned if my daughter was going out drinking and then taking a ride share. Doesn't matter which company it is.
Yeah. Do you feel like that's, I mean, I imagine you're practicing in Houston. Do you feel, is that a national problem with the fracture or is it? Houston?
National.
National.
I have cases all over the nation. You know, I got cases, I even have a case in Alaska,
Sure.
East Coast, California, Texas. Yeah. That one, I think I'm gonna file an MDL in California. I don't think I wanna go litigate in Alaska.
That's funny. So it sounds like, I mean, if you're doing PI work, you're mostly on the civil side. Are you taking it from the sexual assault also on the criminal side? Or
No.
Okay.
No, I haven't done criminal defense in years.
So this is more just going up to Uber and, I guess, I don't know, it's like negligent,
Negligent hiring, negligent training,
and negligent entrustment.
Respondia. They always fight that one. They say they're independent contractors, but it's,
We're doing it for competition right now.
no, but it's mainly negligent and negligent hiring and negligent retention is basically the strongest claims that we have, because they have access to a lot of information about these people.
Absolutely. I don't know, I don't want to go optimistic, I'm like saying it, but just because I'm interested in the type of work you do, that's what my passion is.
Right, yeah. I do. Somewhere around here.
I mean, if not, I'll.
Oh, I'm sure I do. Or maybe I run out. An offense called Kirker. K-H-E-R, K-H-E-R. K-H-E-R squared.
Oh.
Kirker.
Oh, okay.
Google that and it'll show up. I thought I did.
Well, I'm
We're here down
very
there.
great, I'll reach out.
Yeah, I'm sorry.
No,
Yeah, it was.
I'll talk to you tomorrow.
I don't mind having you my phone number too.
Yeah.
I used to have them all everywhere.
Yeah.
Stack everywhere. But yeah, not many people do. Not of them all, sorry. I'll read this too. But I want to be
9 to 10:30 on. 9, it was, yeah, that was the only time the boys, I was in the toilet at class. And so that was the only time the lawyers could be there. I don't get home until, like class.
Trying to get switch over to the. We'll see.
He told me also, I saw him after the hearing. He also said, he's like, I don't know if I want to do a song.
Switch over, no big deal.
Yeah.
But yeah, I wanted to do criminal in the beginning too.
Yeah.
You're good.
And then I started doing PI. I couldn't leave, dude. I got hooks. But it's good. It's fun.
I couldn't be
Yeah.
Yeah.
I'm sure your potential, man, is untapped. My only suggestion, as a humble suggestion, is just keep being open, bro.
Yeah.
You'll never know if someone comes through and they're like, hey, I'll tell you what, Jordy, you got all the skill from the book for us. And if it fucking.
Yeah.
Might as well.
Yeah. I don't know.
Yeah.
At least like.
Hey, good for you.
Yeah, I'm feeling good. I'm feeling good where I'm at.
Yeah. And COEs, bro, you feel that way?
Yeah.
All right, we're outside the, strictly outside the presence of the jury. You see, defense has a mid-trial motion.
Yes, Your Honor, this time the defense was judgment as a matter of law. No reasonable jury could find that Montana Maxis has breached a duty to the plaintiff, and that Montana Maxis actions or lack of actions was the proximate cause of this case.
All right, any response?
Your Honor, so far the defendant has not elaborated on anything that we did prove that would seem to indicate that we haven't carried our burden. The burden is also an extremely high one. We've proven that there was vomiting, we've proven that there's other visible signs of intoxication. I don't see any reason to sustain this motion.
I don't know, the other juries, anything further?
No, Your Honor,
All right, we're back in front of the jury. They have been brought back in. Defense, or first witness.
Yes, Your Honor. At this time, we will be reading testimony, depositional testimony, excuse me, Your Honor. So if my co-counsel may take the stand, as will be Mr. Overton. And Your Honor, at this time, I would like the court to remind the jury that deposition testimony does hold the same weight as one.
Absolutely. So even though this is an attorney reading the testimony of witness, you are instructed to consider this evidence the same way you would if this person was testifying live and in person. This was deposition testimony taken under oath, which was the same oath they would have taken if they were here live in the courtroom today. All right, Ms. Pipes, you can proceed.
Yes, Your Honor. Please state your name for the record.
my name is Al Overton.
What do you remember about that night? Let's start with when you got to Max's.
We got there around 10 or 10:30. The football game was on and we were getting ready to celebrate my birthday.
Okay, I will ask you about that in a moment. But first, did you have anything to drink before midnight?
No, sir. Pretty much the whole bar knew it was my 21st birthday. My friends kept telling everybody that I was going to do 21 shots.
That was not part of the plan?
It was not part of my plan. I just wanted to get my first legal beer and some shots.
Do you know how many shots you had?
5 or 6.
And you still say you were not drunk?
I was not. It was over the course of 2 hours. I had a beer that I was nursing the whole time, and I did a shot about every 15 minutes.
How much do you weigh?
I am about 185.
Is that the same at the time of the accident?
No, I lost some weight. I was around 225 then.
What happened with your friends that night?
They were extremely aggressive and rude to the shop girls. They kept trying to grab them and blame it on me. Finally, I had enough and yelled at them and tried to leave.
Did you leave right away?
No, I sat in my car for about 20 to 25 minutes trying to cool down.
Did you have anything else to drink?
Do you mean booze?
Yes.
No.
What do you remember about the accident?
Not much. I was sitting at the light. It was red. I looked both ways. I did not see any cars coming, so I pulled out.
You were telling me that you did not see Quinn's car.
No, it came out of nowhere.
When did you start drinking the night at Montana Max's?
I couldn't drink until midnight because that's when I turned 21.
Now, this concludes portions of Mr. Overton's deposition. May my co-counsel step down?
Yes, do the plaintiffs have any counter designations?
No, Your Honor.
All right, thank you, Mr. Percy. Plaintiff Carter, or defense Carter, next witness.
Yes, Your Honor, at this time, the defense calls Ms. Dunia to the witness stand.
All right, Mr. Junior, you're up.
Good evening. Please introduce yourself to the jury.
Hi, my name is Max Petunia.
Mr. Petunia, how old are you?
I'm 42 years old.
Where do you live?
I'm Steelton.
And what do you do for a living?
I'm a small business owner.
And what's the business called?
Well, the business is called Petunia Enterprises, but that's just kind of the overarching LLC over Montana Max's Good Time Saloon.
And what is Montana Max's?
Montana Max's is a local bar and restaurant here in town. Pretty much a place where people can come and hang out and just drink and eat.
Where is Montana Max's related?
It's
Located?
It's on Grant Street, kind of the main strip downtown.
How long have you been in this business for?
I've been in the restaurant game for about 15 years now.
And how long has the restaurant been open?
Montana Max has been open for about 5 years, I'd say now.
Your Honor, what I have in my hand is what has been pre-admitted as Exhibit 8. May I push the witness to Exhibit 8?
You may.
Mr. Petunia, do you recognize? Oh, may I, permission to publish the jury?
May.
Do you recognize Exhibit 8?
I do.
What is Exhibit 8?
It is a bird's eye view of the inside of Montana Max's.
Now, looking at that, Your Honor, can I ask if the jury can see, is able to see?
I don't know if there's anything else. All right. Great, see things in the jury box? All right.
Mr. Petunia, looking at this, why are there more dining tables in Marcellus?
Well, we pride ourselves on serving good food and we want people to come in and enjoy our food. As you can see here, our kitchen is pretty big and we want to expand our food options.
And to that, why did you open Montana Max's?
Well, I opened the place because Steelton's not the biggest city in the world, but I wanted to give the college kids and local citizens kind of a place to come and enjoy it and have a good time.
Now, I want to talk about your employees and trainings. Who hires the employees?
Myself or my general manager.
And what positions do you hire for?
Well, we hire for kind of general staff, bouncers, bartenders, servers, kitchen staff, cooks, chefs, etc.
Do your employees get training?
Yes, they do. We take training very seriously at Montana Max's.
And how are they trained?
Well, we have a thing called TIPS, also known as Quality Tips. It's an outsider program that comes in 2 times out of a year. And what TIPS is they train us on how to spot VIPs. These are called visibly intoxicated patrons.
Mr. Petunia, do you attend these trainings yourself?
If I'm not there, my general manager will be there.
And so from those times that you have attended the trainings, what are signs of intoxication?
Well, the signs, Quality Tips people show us to look for are bloodshot eyes, slurred speech, or a stumbling walk.
And what else is taught at those trainings?
Well, they go through situations and scenarios on how to de-escalate and control and turn away visibly intoxicated patrons.
Now, if you or your restaurant determines that someone, a visibly intoxicated person,
which is a local rideshare service, or call them a taxi.
now, are all of your employees trained with Q-tips?
Not everybody gets the Q-tips training because it is twice a year and we do have newcomers come on. And when they do come on, we make sure that one of our veteran staff members kind of shows them the ropes and they get to shadow them.
Now, outside of the Q-tips training and your seasonal employees training the newer members, what else is used as guidance for how to interact with alcohol and customers?
We have a policy and guidelines handbook that we give out to each of our employees.
What I have in my hand is what has been pre-admitted as Exhibit D. Your Honor, may I approach the witness?
Then,
Can we publish Exhibit D to the jury?
if it's already been admitted, you can freely publish.
Mr. Petunia, do you recognize Exhibit G?
Yes, I do.
What is it?
Well, this is a copy of our procedures and guidelines.
Now, looking at this copy, what exactly stands out to you?
Well, as you can see here, we take our very first bullet point very seriously. I believe it's 7.11, and the first statement says you cannot sell alcohol without understanding what alcohol does to the human body.
And according to the policies, what does it say about like the penalty for serving?
So according to our policies, you can lose your job if you serve a visibly intoxicated person, or you can also be fined by the city.
Now, looking at the policy, what do you have what does your restaurant have that might help prevent intoxication?
Well, right, well, still on that first page, if you could scroll down, I believe. Right, that chart right there, that kind of gives our servers and bartenders kind of a brief overview of what to look for, and you can kind of get a guess and a quick eyeball on the individual you're serving, kind of get an idea of how much they weigh and compare that with how many drinks they have.
And what about the kitchen and water?
With
What is your
kitchen
restaurant
and
do?
water, if we determine someone is physically intoxicated, we do try and provide them food, and we do try to provide them water, although we cannot force feed them, but we do have those options available.
And how late do you keep your kitchen open?
30 minutes from the last call.
Now, I want to shift your attention to the night of January 7, 2022. Do you recall that night?
Yes, I was working there.
You were working where?
Montana Max's.
And who else was working with you?
Staff, bartenders, it was a big night. So we had our shot girls come in because it's a crowded night. They walk around and serve shots.
What do you call the shot girls?
We call them mischievous girls, and the reasoning for that is just kind of a playful term. I mean, reality of it, they're just cute girls that people just go up to and get shots from.
And how many of them were working that night?
There were about 8 that night.
Now, the next morning, well, did Mr. Al Overton come into the restaurant that night?
Al Overton did come in at 10:30 on the 7th, I believe.
And so when he came in, did you see him drink?
Yes, Mr. Overton started drinking around midnight that night.
And what exactly did he drink?
Mr. Overton, I believe, had 4 to 5 shots throughout the 2-ish hours that he was there. And, you know, these shots are watered down for the shot girls to go pass around.
Now, did you see him vomit?
I was notified that Mr. Overton vomited. One of my employees said he had a stomach bug or something.
Objection, hearsay.
Response?
Your Honor, this goes to the effect on the listener on what Mr. Montana did after he heard this statement.
Approach, what is he gonna say?
Oh, he just said that his employees notified him that Mr. Overton might have vomited because of his stomach bug. And so he's gonna tell you that he stand up to him and that's why he didn't do anything.
Response, Your Honor? Yeah. Mr. Petunia is still testifying what he heard from somebody else saying, which pretty much fits the definition of hearsay.
Yeah, objection sustained.
Now, without telling me the reason why, did you see him vomit?
I don't believe so. Apparently, he had a stomach bug.
Objection, hearsay.
I mean, yeah, we're getting into testimony that can be determined through hearsay. You have some other exception?
May I have a moment to confer with my co-counsel?
Absolutely.
Your Honor, we are not offering this statement for the truth of the matter asserted, but if you do find that we are, then it goes to presence and suppression.
Someone said that he actually saw this person vomit.
Yes.
Okay. How is it a presence and suppression that is because of a stomach bug?
It goes to how Mr. Overton, well, how this was perceived by those who heard this statement.
Objection sustained.
Mr. Overton, did you see Mr. Oh, sorry, I apologize, Mr. Petunia, did you see Mr. Overton knock over a tray of drinks?
I did.
Can you explain to the jury what happened in this situation?
Yeah, so apparently in that time frame towards the end of the night, Mr. Overton was accused of touching one of the shot girls. I don't think he did it, but his friends may have accused him of that. And I believe he became agitated because of that, ultimately knocked over the tray.
Objection, speculation.
Objection.
Now, did you see him argue with the bouncers?
He did. It was his 21st birthday and we were trying to get him out and he was not pleased that he was being escorted out.
Why did your employees try to escort him out?
Because he became agitated and part of our policies and handbooks, I believe it's 7.5 there at the end. But if we determine that a patron is not visibly intoxicated and they are in fact agitated, we must get them out because we are in a bar. If someone's agitated in a bar, I do not want fights happening or an all-out brawl in the middle of the bar.
Now, Mr. Petunia, you were here when Ms. Chase was testifying, correct?
Yes,
And did you hear her say that you own those parking lots by your restaurant?
I believe so.
Do you own those parking lots?
I do not think so. I'm not entirely sure which parking lots we're referring to.
Do you own any parking lots?
No.
Does your restaurant sell bad dog liquor?
We do not serve bad dog liquor.
Mr. Petunia, would your restaurant ever serve an underage customer?
We would not ever serve an underage customer.
Would your restaurant ever serve a visibly intoxicated person?
Absolutely not.
Would your restaurant ever let a visibly intoxicated person drive?
We would not let a visibly intoxicated person drive.
Now, we previously talked about the signs of intoxication. So at any time when Mr. Overton was in your restaurant, did you see him with bloodshot eyes?
I did not.
Did you see him with a staggered walk?
I did not.
Did you hear him with slurred speech?
No.
No further questions.
All right. Representative, Mr. Buckley.
Yes, sir. Mr. Petunia, how you doing?
Good, thank you.
Good. I'm glad. I want to talk about Mexican Monday. Is your purpose for doing Mexican Monday to sell half-price dishes and drinks?
Yes, the Mexican Mondays, we have half-price dishes and drinks, and we also have half-off Coronas and margaritas as well.
Thank you for that answer. Are you wanting to give people a chance to let off steam?
What do you mean by that, sir?
Well, when you bring in people for half-price drinks and cheap dishes, are you wanting them to let off steam?
Objection, Your Honor, they.
Yeah.
Chance to
raise the
respond?
question. Raise the question.
Have you ever testified to the fact in a deposition that you want people to let off steam?
Generally let off steam. Do we have like a context to pair that with, or just let it?
Would it help refresh your memory if you saw where you said this in your deposition?
I think I understand your question. We like people to come in on Mexican Mondays because we have prizes and games, and if they want to come in and let off steam, we're happy to do so.
So let's talk about the training. You train your staff in tips every 6 months, as you said, right?
I personally do not train them. We have an outside third party that comes in. It's quality control tips that comes in and does that for us.
So every 6 months, someone comes in to train your employees in tips.
Yes.
What happens if someone is hired right after that training?
Right, there is a gap. And if they get hired in that gap, we have one of our veteran members kind of shadow them throughout the restaurant bar. And especially we make sure we get those policy procedures handed out.
So that shadowing process is not in your policies and procedures, though, is that correct?
I do not believe it's wrote down in there. Because
So there's-
we get that as
Oh,
well.
excuse me. I apologize, I didn't mean to interrupt.
No.
So there's no written record of what the shadowing looks like?
No.
Let's talk about your Miss Mischievous girls. Are they trained?
Yes, they do not always get the Q-tips trained.
Then how are they trained?
Our shadow observers that we have.
So the shot girls and the Miss Mischievous girls, they shadow as well,
Yes, sir.
but they do come in relatively infrequently. Is that correct?
Right, because when we expect bigger crowds, we do bring in the girls to come in and maneuver through the crowds.
Are they told not to sell multiple shots to the same person?
That's correct.
Would you be watching all of your Miss Mischievous girls the whole night, each time that they're in the restaurant?
The best that I can do, sir.
Can you watch all 8? Or let me back up. How many were there the night that Oliver was there?
About 8, sir.
Can you watch all 8 at all times?
I do my best.
But you don't have a good relationship with these Miss Mischievous girls. Oh,
I hope I have a professional relationship with all my employees, nothing more.
but one of them could sell more than one shot to a customer. You might not.
I sure hope they want it.
You hope, but would you know?
I guess I can't believe it possible.
So I want to turn your attention back to Exhibit D, which was pre-admitted. You were just looking at it with one of your attorneys. And if we could go ahead and get that up there as well, that'd be great. Oh, I'm sorry. Let's go to 7.2.1. So you did say that you were there the night that Mr. Oakland was there, correct?
Yes.
And you don't believe that he was visibly intoxicated?
No, sir.
So I want to direct 7.2.1, the last bullet point, says carbonated beverages may speed the rate at which alcohol is
Objection,
sold.
Your Honor, cumulative.
I was setting the stage for my question. I didn't-
Yeah.
Were you aware that Mr. Overton was drinking carbonated beverage?
Like soda?
No?
I don't think he was.
Was he drinking a beer?
Yes,
And you knew that?
yes.
And you knew that that would affect his BAC?
I generally knew, I'm not an expert in BAC, but I knew any alcohol does have a general effect.
So let's move on to 7.4.1, observation of guests. This one says change of behavior is one of the best indicators of intoxication. Yes or no? Were you aware that Al Overton's behavior changed that?
I don't, what do you mean by that? Like,
Did he suddenly get angry?
yes,
7.4.2, if a guest becomes overly friendly, depressed, loud, or rude, begin careful observation. Were you aware, yes or no, that Al Overton became suddenly loud?
when they walked in, they were loud.
Did he become suddenly rude later on?
I'm not entirely sure.
7.4.3, impaired motor coordination. Are you aware that Mr. Overton knocked over a table and trays yesterday?
I did see that, yes.
So just to sum up, you're aware he knocked over a table and trays, yes or no?
Yes.
You're aware that he became, or excuse me, you're aware that his mood changed.
Yes, I am.
Okay, and then finally, you're also aware that he vomited, correct?
Yes, I did.
And you still claim that you did not think he was intoxicated.
No, I do not believe it's intoxicated.
Finally, let's go to 7.6. It says you should never let a guest that you suspect to be intoxicated leave the premises. You still don't think that Al Overton was intoxicated,
No, sir.
and that's why you let him leave the premises.
Correct.
Thank you. No further questions.
All right, any readers?
No, Your Honor, may the witness, step down.
You may. Next, finance witness?
Yes, Your Honor. Defense called Sean Malcolm. And Your Honor, at this time, I would like to read in the stipulation to the record, specifically number 22.
Any objections to the reading of 22?
Yeah, Kevin, may I just get a moment? Yeah, no objection.
Okay,
Okay, proceed.
may,
Stipulation 22, Sidney Crosby and Gene Malkin are deemed qualified as experts to render opinions in the field of hospitality and service of alcohol. May I proceed, Your Honor?
you may.
Good afternoon, Dr. Malkin. Can you introduce yourself to the jury?
Good afternoon. My name is John Malcolm.
And can you tell the jury briefly why you're here today testifying?
I'm here to render an opinion on whether or not Montana Max violated the standard of care in regards to serving Al Overton alcohol on January 8th.
And Dr. Malcolm, we'll get to that opinion in a second, but first I want to talk about some of your background. Can you tell us about your education?
Absolutely. I have a bachelor's of science in pharmacy and hospitality. I have a master's of science in toxicology, and I have a PhD in pharmaceutical chemistry, all from Steelton State.
Dr. Malcolm, what do you do for work currently?
I work at Buffalo Wacky Wings.
Tell the jury, what do you do at Buffalo Wacky Wings?
I help them create policies and procedures to help notify staff how to spot signs of intoxication and how to mitigate the risks associated with that.
And how long have you been at this position?
I've been doing that for 2 years now.
So did you do anything prior to that?
Yes, for 14 years, I worked at Westin Hotels. I was a tips instructor.
Okay, explain to the jury, what do you mean tips instructor?
So TIPS is an abbreviation for training for intervention procedures. What we do is explain to our clientele across the country that what does it take for someone to become intoxicated? What are some signs that you should be looking forward to? And when you do see those signs, what are the ways to mitigate those risks as well? We create pamphlets and procedure manuals.
Thank you for that explanation, Dr. Malcolm. Now, have you reached a conclusion in today's case?
I have.
And tell the jury, what, if anything, did you review in making that conclusion?
I reviewed all deposition transcripts and exhibits for the case today.
And is your conclusion based on a reasonable degree of professional certainty?
Absolutely.
Dr. Malcolm, tell the jury, what is your conclusion?
Jury, my conclusion is that Montana Max did not violate the standard of care in regards to serving Allerton liquor and alcohol on January 8th.
How can you be so sure?
There's two big reasons that guide my conclusion. One of them is that Montana Max, like other reputable bars in that area, what they do is they have a set of policies and procedures. And to the best of their ability, they're making sure that their bartenders and servers are following that. And also, Allerton did not show signs of intoxication or of visible intoxication that weren't accounted for other reasons.
Hey, Dr. Malcolm, let's take that one step at a time. Let's talk about the policies and procedures first. Your Honor, permission to approach Exhibit D. Permission to display Exhibit D for.
It's been admitted,
Yes.
Publish, Your Honor, I apologize.
all right, it's already been admitted, correct?
Yes, Your Honor.
You may freely publish anything that's already been admitted.
Yes, Your Honor. Now, Dr. Malcolm, what are we looking at in Exhibit D?
That's the first page of the policies and procedures that Montana Max has.
Have you read this before? You said earlier the policies and procedures were adequate. How so?
Well, there's numerous pages of this. I mean, the law only tells you, and I'm sure the judge will get into that, but you're not supposed to be serving alcohol to someone that's visibly intoxicated.
Objection, Your Honor, this calls for a legal conclusion.
How so?
Your Honor, I believe that the only court that should be explaining, or the only person that should be explaining to the jury what the law is you, Your Honor. For this witness to conclude what the law requires is a legal conclusion that the jury shouldn't be allowed to hear from this witness.
Responses, types?
Yes, Your Honor. This expert witness has reviewed what the laws of Steelton were. He's simply putting it to the jury in a simplest form. He's not trying to explain the law. He's just furthering his testimony to why this policy is applicable.
This is not an ultimate issue, right?
Your Honor, I'm not quite sure where he's going with this. I do believe it could veer into ultimate issue if he describes liability. I would just like to make that clear.
Understood. It's a little.
Dr. Malcolm, I'll ask you again. What about these policies and procedures make them adequate, as you said earlier?
These policies and procedures require a lot for a bar, you know. In these policies and procedures, you can see sections that explain what VAC is, explain how that affects the body. But they go further of saying, like, you know, free food, make sure they're drinking enough water. If someone's getting too drunk, get them a cab, get them, you know, spend money on all these different things, make sure that full kitchen and bar tab is open for at least 30 minutes before closing. So it goes through a lot of more details and procedures than, what they're required to do.
You said more than what they're required to do. Is this the law?
Now,
Then why have this at Montana Max's?
just because it seems as if, Montana Max cares about the safety of their patrons. The reason why bars have something like this is just to make sure people are safe.
And why is that important to make sure people are safe?
When you understand what alcohol does to the body, you know how to mitigate that risk.
Hey, Dr. Malkin, I want to move on from the policies and procedures. You mentioned earlier that Mr. Overton was not visibly intoxicated. Again, how can we be so sure?
Absolutely. So, Mr. Overton, as you heard, one of the attorneys step up here and read his deposition. He weighed 225 pounds the night that this happened. Now, through depositions and testimonies and so forth, Mr. Petunian has said that, these are some watered down shots that he's serving. He's been having these every 15 minutes over a course of a couple hours, course of 2 hours, and he was sober until midnight. So in a span of about, an hour and a half to 2 hours, there's no way he could have been showing visible signs of intoxication up until, the breathalyzer, which happens 2 hours after that.
I heard you just mention a breathalyzer. Was anyone breathalyzed in this case that you know of?
Is Mr. Overton in this case?
Yes, apologies. Was Mr. Overton breathalyzed?
Yes.
Do you know what the results were?
He blew a 0.12 with a 0.03 degree of variance.
What do you mean variance?
So the reason why the breathalyzer was defective was because he blew a 0.12 and it could have been anywhere in the range of 0.09 to 0.15.
And does this variance affect your conclusion in any way? The fact that it was defective?
Absolutely. And, even if it wasn't defective, what it shows us ultimately is that 2 hours after this, after he left the bar, when the accident happened, the police came to the scene and they breathalyzed him, that's when the peak of his BAC occurred. And it was at a 0.12. For someone to be showing visible signs of intoxication, they have to have a 0.15 BAC. And there's no way that could have occurred while he was at Montana Max's because, frankly, it takes time for alcohol to metabolize within the body and for him to reach those levels.
Dr. Malkin, in your review of the materials, how did he reach those levels around the time of the accident when he was breathalyzed?
Just with time and your body metabolizing it and sending it through the blood. That's how blood alcohol content works. I'm sorry if I keep using BAC, but that goes through those portions. So if like someone vomits and stuff, that disturbs the process. You have alcohol exiting the body. And those are all different factors that one needs to analyze.
Okay, I heard you mention VLG a while back. Can you briefly describe that for the jury? What do you mean? Does that stand for something?
Yeah, just blood alcohol content.
And can you give just, again, a brief meaning of what do you mean when you say blood alcohol content?
So just like how much alcohol is within someone's body at that specific time.
Do you remember in your review of the materials reading about how Mr. Overton waited in his car for around 20 minutes?
Right, and I also saw something else. There's a half-empty bottle of liquor in his car after that 25-minute period. There would have been, no way for him to reach the amount of intoxication that he was at while he was at Montana Max's without him drinking other foreign substances. And with that, and with the stains on his shirt and all those signs, it shows that, he may have been drinking something else after he left Montana Max's, gotten drunk, and led to the unfortunate incident of the accident with Mrs. Chase.
Now, I noticed you said he may have. Are you 100% certain that Mr. Overton had this bottle you mentioned?
No.
Anything from the bottle?
No, just besides the circumstantial evidence of, having his shirt in the same color, he had the purple stains and the bottle was the purple bottle. Mad Dog, I believe, is what the kids call it these days.
Thank you, Dr. Malkin. You mentioned earlier that it is your professional opinion that Mr. Overton was not physically intoxicated, but you know that he vomited, right?
Yes.
So how can you make sense of that?
So yeah, what matters is if he is visibly intoxicated to the bar and if they continue to serve him after that point. All the evidence that I reviewed doesn't show anything of them serving him alcohol after the point of showing visible signs of intoxication. But vomiting is a factor that you always look at and you always want to be wary of. Through the deposition testimony that I read today, it was clear that the bartenders or the staff heard about the stomach bug.
Objection, Your Honor. Here's that.
Yes, Your Honor. I believe this expert has relied on hearsay and coming to his conclusion, so he would be allowed to explain to the jury what he based his conclusion on.
Response on those grounds?
Yes.
Your Honor, the witness is allowed to say that I concluded vomiting was different from something else other than drinking, but to specifically disclose the fact that he was overheard that he had a stomach bug, it's just using this witness to factor in this hearsay. You can only disclose that if the probative value outweighs any prejudicial effect, and that's just not
Yes, Your Honor. This would not be an admissible hearsay, even if this witness was a lay witness, because see, this hearsay is twofold. It's when Mr. Overton explained to an employee we overheard that he had a stomachache. Now that would be a present sense impression. The condition that he was experiencing at the time, which was a stomachache, he was explaining. Well, that will take care of the first layer of hearsay. In addition to the second layer, when the employee told Max Petunia, we're not offering it for the truth of the matter. We're offering it for not the effect of the listener, but it having no effect on the listener, Your Honor. So by definition, it would not be hearsay.
Well, let's do this. Lay foundation showed this expert actually relied upon this information and allow it or underlying facts.
Yes, Your Honor.
Your Honor, just to get a ruling on that.
Dr. Malkin, did the fact that Mr. Overton vomited play a part in your overall conclusion?
Yes, as I've said, that's one of the factors that you want to be wary of whenever you're serving alcohol to patrons. So if someone's vomiting, that can be a sign of visible intoxication sign.
You say it could be a sign of visible intoxication, but yet you say he wasn't visibly intoxicated. Can you explain that?
Right. So with this factor, an apparent explanation to it at that point was that he had a stomach bug, and that was the reason why he had thrown up. At least that was what the bar staff had was told, and that's what I relied upon in my testimony to be able to stand here before you today and make sure that I'm giving you an adequate response.
Thank you, Dr. Malkin. I want to talk about Mr. Overton spilling a tray of drinks. Did that play a part in your conclusion?
Yeah, again, these are visible. These are signs that someone could be intoxicated. So you have to take all the circumstantial evidence and make something of it. In this light, when we look at these fact patterns, what we see is that Mr. Overton spilled the tray of drinks. So that could either be someone stumbling because they're so drunk, or that could be them being so mad and doing that. Well, throughout looking at the records, apparently he was. This may be kind of harsh, but he was. There was allegations of him inappropriately touching these chakras. So if someone hears an allegation like that, it would be reasonable to conclude that they would be agitated, therefore smacking over the tray. So that could be, again.
In your professional opinion, was Mr. Overton agitated when he was at Montana Max's January 7th and 8th of 2022?
It definitely seems so. I mean, he got into a set of arguments with the people he came with, his friends, and then the bouncers at the doors, smacking over the table, spilling over, these drinks, and heading out. All of these seem, like there was like a football game going on, their team lost and stuff. So there's a bunch of stuff that we're looking at that shows that, he must have been very mad that day. He must have been very agitated that day. But yeah.
And so I have to ask you before I sit down, were you in the courtroom this whole time?
Yes.
Did you hear Mr. Sidney Crosby's testimony?
Yes.
Did you notice it was maybe different than yours?
Yes.
Can you explain to the jury the discrepancy? Why should they take your word?
Well, as expert witnesses, we're accounted for our time. Just making sure we're coming here, we're reviewing the materials, and we're getting paid adequately for that. Mr. Crosby, seems that, he owns the competitive bar and there's like maybe there could be other advantageous portions, for advantageous points for him to be. And beyond that, I have masters in toxicology. I have a PhD in pharmaceutical chemistry. Mr. Crosby has a Bachelor of Arts, not to, make a big deal out of that, but those are just the facts before us today.
Dr. Malcolm, I'll ask, in your professional opinion, was Mr. Petunia, Montana Max, reasonable on the night of January 7th and 8th, 2022?
Yes, because they abided by what their policies said. Their policies say that if someone is visibly intoxicated, you don't serve them any alcohol, but if someone is agitated, you make sure they're outside the bar. This is a 225-pound man, big guy, getting into arguments with people. It's the safest for the people inside that bar if you would step outside for them to make sure that he is outside.
Thank you, Dr. Malcolm. Councilman Pastor.
Trustee Ross.
Yes, Your Honor. Dr. Malcolm, policies are important, right?
Yes,
Keep people safe.
yes.
Make sure customers can drink in peace. Right?
Yeah.
Make sure that people don't get too intoxicated, go out in the street and get into accidents. Right?
And cause accidents even with them.
Right, drunk driving, it's a terrible thing, right?
Absolutely.
Bars should take every precaution necessary to prevent that from happening.
As much as they can. Yeah.
And the policy, it's only as good as it's followed, right?
I would say so. Yeah.
There's no point in a policy if you don't even follow it. Is there?
Definitely say that. Yeah, I agree with you.
I want to talk about some of your conclusions related to blood alcohol content. Now, BAC, it's just a percentage of alcohol in the bloodstream, right?
Yes.
So if I have a BAC level of 0.01, that means 1% of my blood is alcohol, right?
No.
What does it mean then?
It means that 0.1% of the volume of your alcohol contains alcohol. 0.1% of your blood contains alcohol.
Right, so the volume level of the alcohol in my blood is 0.01.
Yes.
So you're saying that someone needs to have a blood alcohol content of 0.15 to show signs of visible intoxication, right?
That's true.
So someone's blood alcohol content volume level has to be 15% to show signs of visible intoxication.
And again, these aren't things that you can put a blanket term and say this is the exact number that it takes for every single person to be visibly intoxicated. But for most people, at least in our field, we are instructed that 0.15 is that place that you can, on average, say that happens.
So there are exceptions, right?
Yes.
Someone could show signs of much less, right?
Signs of visible intoxication.
Yes.
It is unlikely if it's much less. Overwards, yes, but the variance is on a plus side of the spectrum, not a negative.
Well, you're aware the legal limit is 0.08, right?
The legal limit for what?
For driving drunk.
Yes.
So you're saying that to show visible signs of intoxication, it's almost double the legal limit?
That's why they breathalyze people, because even though they can't be showing visible signs of intoxication, they could be.
And that's not my question. My question was, you're saying the signs of visible intoxication are almost double the legal limit. And that's what you're saying, right?
I don't understand.
You don't understand that question.
I don't understand the question.
You're saying the signs of visible intoxication are 0.15.
Yes.
The legal limit is 0.08.
Yes.
0.08 times 2 is 0.0 or 0.16, right?
Yes.
That's almost double the legal limit, right?
0.16 is double.
Right. And so it's much less for the legal limit than what the visible intoxication signs are, right?
It's much less. What's much less?
0.7.
0.7 is much less.
Is it less?
I'm sorry. Can I get some help here? I don't understand the question.
Doctor, you have a PhD, right?
Yes.
Master's in toxicology.
Yes.
You telling this jury you don't understand what 0.7 less is?
I understand what 0.7 less is. I just don't understand your question. You keep asking 7 different questions at the same time. I guess that's why you get paid so much. I don't understand what you're asking.
Okay, doctor. But I want to talk about the policies and procedures that the defendant's bar has. Now, you talked a little about earlier, but you didn't really go into depth, and I want to take the chance to do that. If we could get 7.3 on the screen, Mr. Buckley. These are the defendant's policies, right? I want to start with bar tabs. Now, tabs are a great way to keep track of the guest drinks, right?
Yes.
It's one of the best ways to make sure someone is maybe intoxicated, right?
They're highlighting, I can't see it. Yeah. Most of the time, yeah.
Right. And it says in here, each time a party orders a drink, place a receipt in a clean highball glass in front of that party, right?
These are best practices.
That wasn't my question. I asked what it says. And it says, each time a party enters a drink, place a receipt in a clean highball glass in front of that party.
Yes.
That wasn't done for Mr. Overton.
No,
No one placed a receipt, right?
I just said no, sir.
No one knew how much he had to drink that night based off a bar tab.
Based off of the bar tab?
Yes.
I believe you paid cash, so.
There was no tab, right?
Right.
Yeah. And I want to move down to 7.4.2 or 1. Now, change of behavior is one of the best indicators of intoxication, right?
Yes.
And you can agree on that, right?
Yes.
When someone comes in quiet and reserved and then suddenly becomes loud and boisterous, that could indicate they're intoxicated.
Yeah, but you came in shouting, so I don't know how much this helps us.
Well, he didn't come and start fights, did he?
Right.
He started fights after he started drinking.
Yes.
Relaxed inhibitions. If a guest becomes overly friendly, depressed, loud, or rude, that's a sign that they might be drunk, right?
Yes.
And that happened to Mr. Overton, isn't it?
Yes, these are factors.
All right. Let's flip over to these next couple of sections here. The last section. Impaired motor coordination. This is perhaps one of the most obvious tells of an intoxicated patron, right?
Yes.
They start stumbling,
Yes.
they knock things over.
Yes.
That happened to Mr. Overton.
Yes.
He was stumbling.
We don't know if he was stumbling.
Well, he knocked over some drinks.
Right.
We don't know if he's now, to be clear, he never said, gosh, I'm so angry about being accused of something. I'm going to knock over these drinks. Did he?
I don't think that's in the record, sir. No.
Right. He never said that. Right.
I don't. By
Well,
my
there's no
review,
evidence.
by my review of the evidence, yeah.
All that's in there is that he knocked over a tray of drinks, right?
Yes.
We can all agree that these are signs that someone might be intoxicated, right?
Yes.
And to be clear, in 7.6, it says you should never let a guest that you suspect to be intoxicated leave the premises, right?
Yeah, and in the last line, it says, however, should a guest be agitated and not intoxicated, make every effort to remove the guest as soon as possible.
I appreciate you reading that on your own. But my question was, you should never let a guest that you suspect to be intoxicated leave the premises, and that's what that says, right?
The first line, yes.
Right. It also says a couple things you can do, right?
Yes.
Call a cab.
Yes.
You can call a friend to take him home, right?
And I believe that's what was in the record. He had said he was having some.
Oh, hold on. He told Max Petunia, I'm getting out of here.
No, he also said he had arrived in that deposition.
I'm not talking about Mr. Overton's deposition. I'm talking about what was told to Max Petunia when she testified.
Right, in Max Petunia's deposition, that's what he had said.
That you're saying that he said he got arrived.
Yes. That he said that he had arrived. That's what he said.
Okay, but he did hold up his keys, right?
Yes.
And he said, see you suckers.
Yes.
So he's going to meet up with a friend outside. How do you explain that?
I don't know what I wasn't there to tell you exactly what he meant by that, but he had told Mr. Petunia that he had arrived. That's what I reviewed in the evidence that I looked at. Gunner.
Max let him go that night. Right?
Excuse me?
Max let him go.
Let him go?
Yeah.
As opposed to restraining him? Yes.
As opposed to offering to call a cab.
Yes.
As opposed to offering him some food.
Correct.
As opposed to offering him some water.
Correct.
Just let him go. Right?
Yes.
And then he hit Miss Chase. Shortly after.
He is Mr. Overton?
Yes.
Okay, yeah, not Mr. Overton.
No, Mr. Petunia hit.
Right, correct.
Mr. Overton.
Yes.
After leaving the defendant's bar.
Yes.
After having 5 to 6 shots.
that part of the record is quite shoddy. You see, we don't even know exactly how many shots he had. There's deposition testimony anywhere from 4 to 5 to 6 shots.
Shot every 15 minutes.
Again, like there's convoluting evidence that supports all of that.
My question was, he said he had a shot every 15 minutes, right?
Yes.
That would be 6 to 8 shots.
If you count, he was there for an hour and a half, that would be 5 shots.
Every 15 minutes from 12 to 1:30/2.
Well, if you're counting the time that he's like getting in arguments with friends and going outside and doing this and this and that, if you count all that stuff in, there's a variance with that. I can't, none of this is a science.
Thank you, Doctor. No further questions.
All right, any redirect?
There you are. I just witnessed it.
Defense counsel, did you vote?
No, Your Honor, we signed the rest.
Okay. Is there any matter we need to take up?
No matter from the plaintiff, Your Honor, you have to brief 5-10 minutes.
Let's go 10 minutes so we can get the count this out. All right, for research.
Well, we can give us time to figure it out.
Yeah.
I tried, but it was a learning curve. I mean, it was probably one of the hardest things I had done.
100%.
It was really hard. Oh, I was exhausted.
Oh, and then I had to wake up and work out because my heart was still pounding. So,
Dude, the first time I went to bed, I really set to go up and like change a whole bunch of stuff, right? To see how it actually plays out and
That's right.
it's very different when you're scrimmaging like against one another to like when it's actually in the courtroom and it's more adversarial, right? And so I had to go home and change a bunch of things and like going to bed, my heart was so racing. And I'm like, it feels like I just worked out. And I've taken a melatonin. I'm trying to go to bed.
I had to worry, I was thinking,
Yeah.
Give me your time.
I'm doing 2 big holes in the face. Like that. That was real life. We didn't have any. So what's your name?
Scott.
Scott. Rick.
Hey, Rick. How are you?
Nice to meet you.
See you.
Judge these a lot. So you're saying you know him?
Yeah, mostly.
The defendant in the state of Florida.
Oh, it's not-
Really?
Yeah, and then regional.
Did you go to South?
Yeah.
Okay, that's where I'm at right now.
Yeah. It's fine. It's good.
Oh, I love it.
Of course, I have a good court, new trial. There was new ages coming along used to. So I was doing a lot of regional stuff. I think I did this national.
The bathroom.
Yeah.
So you're a judge here in the building?
Yeah, no, I vested and resigned. Once I vested in the retirement program. I had kids starting college. You know, I got this. So I resigned for this building.
Okay.
So I was in real long. It was not look that nice. It looked that nice until recently. And they redid it. It's really a spectacular building now.
Yeah, I'm interning with Judge Foley.
Yeah, I haven't seen Judge Foley in a while. Still working out all the time.
Not as much, but he's trying to.
I used to kid him. I said, don't invite me over your house for barbecue. You know, maybe go to your yeah, your whole his backyard like. workout deal. And now you
Still
put through it.
congratulations.
And then I haven't seen him.
Yeah.
So,
What's your last name?
maybe was,
Colleague.
yeah, right.
That has one.
Yeah, Thomas.
Yeah.
Oh, yeah, I love watching. Yeah, I learned so much from him. He's really great at it. You know, you can tell just by the amount of work he puts in and
Yeah.
everything he knows about it. You know, it's really really special opportunity.
It's a hard job.
Oh, no, just the amount of work that is out in front of him. See him going through it. Yeah, it seems crazy. Seems like a lot.
It's hard. Hopefully it's close to it.
Yeah, me and Lola are just starting this summer.
Oh, really? Okay,
Yeah,
good.
so,
How far along are you?
pretty early, spring start.
Okay.
Yeah, so one semester in.
It's a great, yeah, sit in and watch how it's It's a great learning.
Mhm. Yes, we both had a Professor Moore in South Texas too. So, you know, I told him that. Oh, I was like, awesome, all right.
I taught at South Texas for a while, triad.
Really?
Yeah, just Williamsville, my students.
Really?
Small world.
No, it is. It's supposed to be the biggest.
I had two ex. Ex-students come to. Judge Williams and the other one.
Yeah, it's been a lot. I just don't think about it.
I'm like, get up. Yeah.
It's good to do, trust me. This is good running around.
No, like, I just, I, with a certain amount of time, I.
Yeah.
Let me know when I watch it.
Not really. I don't think so. What it looked like it was last night. You know, like trying to get
I did that scheme. Let me know when.
Fair enough, fair enough.
Well, I was Friday a lot, the docket day was really.
Mine was Monday. Summary judgments, policy eight, 8:20, 8:40. And then I started buying. Zero.
While we should still find.
I was rather than jury trial.
They're hard.
I didn't get that.
Oh, man, they're hard. They really
40.
That's true. That is
A year.
My first round.
Yeah. And I think that's good.
You know what?
Now they-
The way you guys are
9 day.
It was great.
Yeah. A lot more traffic than that.
Even more.
Now you have to be hard too. I mean, just even the storm, you know, storm, power company, yeah.
That didn't help. Nobody saw that. Nobody saw that coming.
Yeah. So, you know, I don't know. You definitely hard. You have a trial.
Okay, yeah. So
What?
There was a lot, you know, last year, we traced that one.
My last year on the bench.
Yeah. Actually, I don't know.
No,
I'll
it was
do.
only 6 months, between 6 months and 18 months. Pick a week. Now, remember that you're going. Yeah. So I'm not ready. You're going. So anyway, that's kind of fun time.
I think it did. No, no,
11 years. Yeah, it was. Our county group was me, Abbott, with that. And then Kate Kennedy. No, Kate Kennedy. Kurt O'Neill, so I was glad to see women come. When I first started trying lawsuits, we had 25 school district courts, I had 24. I would say all the district courts are more through. My prediction in 4 years, 90% of the courts will be winning.
I mean.
Well, you know, I'm cool with that. I mean, it was all men for a long period of time.
Yeah, somehow I've described it. He went maybe just 10 years ago. When he went out, the top, like it's almost like all guys.
Yeah.
70, 80%. Now it's
A lot more.
yeah, the slingshot class, we only have 2 people. So it's like, 25.
Yeah. When I was there, probably 8, 20.
Yes, no, it's definitely a lot. Landscape change.
Which is good.
That's good.
Yeah. I feel like they have a team as far as spread of demographic.
Kyle told me you guys like.
I was like.
Yeah, I went there for undergrad. It's crazy. That would be a different way.
The more.
So I was.
I was like, oh, they beat us all. Which they could. Now I can ask them like.
Minority at that time. 60%. Oh,
60?
yeah.
Wow.
Yeah. Yeah. I'm sorry. Well, yeah.
You know, I know they went to Wills.
So Hillary Clinton.
Yeah.
Madeline Albright. There's one like newscaster, I think she passed away.
No, I know somebody else.
Okay.
Okay, like this color.
Yeah. Almost fucked up.
Yeah.
That's what I always do.
It was just too. No, it was wide open. My entire class, pretty much 80% of my entire graduating class.
Really?
Yeah.
You grew up here, Jesus?
Yeah.
Yeah.
Nick.
Because I have.
Yeah.
That's always 20 minutes. Shit.
Or.
Oh my God.
Yeah, that's really good. I've known that.
I was trying to get into the fact
It's so fun.
they come in and out.
So now you're doing it.
Yeah.
That was so funny.
I am. I do a lot of mediations.
You need work out for class to go with.
Yeah, I do. Yeah, and I testify to I represent.
You too.
Yeah. Yeah, we just. For my, I did not. Sure came back in 10 minutes. Yeah, they were. He wasn't that upset. She was like, she wouldn't even let me offer a rule where if you make an offer and they reject it. They are on the hook for all, man. I went for I don't know. How do I end up producing? I was representing. We're not on.
All right, everybody, proceed.
Yes, Your Honor.
All right, everyone can be seated. But everyone's my understanding you have over 20 minutes available for closing argument. You don't intend to use all of it.
I do not, Your Honor.
All right. Whenever you're ready.
Yes, Your Honor. May it please the court. 4 words. 4 words were all that was needed to prevent any of this from happening. 4 words were all that Mr. Petunia needed to say to prevent Miss Chase from breaking her collarbone, breaking her femur, rupturing her spleen, and bouncing her head off that car window, giving her a concussion. Give me your keys. That's it. But because the defendants failed to monitor Mr. Al Overton, failed to adhere to their own policies, failed to say those 4 words, Ms. Chase got hurt. And because of that, you're going to find why. But let's go back to the very beginning and talk about what all happened. Now, you heard about exactly what Mr. Overton did that night. You heard that he arrived at that bar at 10:30 p.m. And he made his plans clear. I'm going to do 21 shots. Folks, when someone comes into the bar claiming to do 21 shots, you should probably pay attention to that. As you heard the testimony today, drunk driving, people getting overserved, it's one of the worst parts of the bar industry. It's a danger to every single person that gets out on that road. Now, the defendants could have done things in their own policies, things like keeping tabs on people, like keeping an actual record of what drinks are being ordered, like training their employees properly, like making sure those shot girls receive more than just a shadow training, whatever that is, was never defined. They could have done more. They could have followed their own policies and procedures, but they failed to do that. Now, you heard that Mr. Overton started drinking at 12 a.m. that night. And he claimed in his testimony, I know there's been a bit of back and forth, and that expert, oh boy, was he going back and forth on how many shots we had. But folks, you heard it from Mr. Overton himself. I had a shot every 15 minutes. Those are the words of his testimony. I'm not great at math. Went to law school to avoid it. But if I do the math, from 12 a.m. to 1:30 or 2, that's 6 to 8 shots. in the span of 2 hours. The defendants knew that he drank that much. They said so. But in addition, that's not all Mr. Overton did. He vomited. I know there was a little bit of a dispute about a stomach bug, but you got to remember who's telling you that. The hired gun of the defense. No one else has come up here today and claimed that Mr. Overton had a stomach bug. It was the first time we heard it in trial. Because they know they can't explain it other than that. You also heard that he was stumbling around, getting into fights with people, yelling, knocking over trays of drinks. Members of the jury, the defense wants you to think it's all a coincidence. Every part of this is coincidence after coincidence after coincidence. It's not. It's a pattern. A pattern of evidence that shows that Mr. Overton was visibly intoxicated. It's a bar. Mr. Petunia's been working at him for 15 years. He knows what a drunk person looks like. Or he should, at the very least. But no, all that was just because he was upset. I guess he vomited because he was angry. I guess he got into that fight because he was angry. I guess he knocked over those drinks because he was angry. It's not reason. It doesn't make sense. Now, what happened was Mr. Overton was asked to leave that day. Now, the defendant has policies.
Objection, Your Honor, that key is not.
Like that, the actual key.
It's a
Yeah,
proper
that
honor.
entire key.
I'm gonna assume he's demonstrative. I'm gonna send it back to the jury.
Thank you, Your Honor. Now, the defendant has policies of what to do when someone's very intoxicated. It says if you even suspect someone to be intoxicated, you cannot let them leave. You ask for their keys. You get them some water. You offer to call them a cab. You do something. And you know what? The defense has actually said something so interesting that I just had to write it down. When I walked through the signs Mr. Overton showed that night with this expert, and I said, those are signs he was visibly intoxicated. He said, yes, they are signs he's visibly intoxicated because he was. And the policies that the defendant has says if you even suspect that someone's very intoxicated, you do these things. And they weren't done. They weren't done. And because of that, Mr. Overton left that night. Got into his car, and it's disputed about whether or not he drank something in the car. But folks, that's not what's important. What's important is they let him leave, knowing he had done all these things while in that bar, knowing that he was intoxicated. Because of that, they're liable. Because of that, Mr. Overton got into his car and he rammed it into Miss Chase, T-boned her. Folks, Miss Chase took the stand, heard what it sounded like. Metal tearing against metal, head bouncing off a car window, a lurch forward, shattering a collarbone, breaking a femur. Those aren't just a fender bender. That's a serious accident that put her in the hospital for days. Required her to get physical therapy for 3 months. Made her drop out of school for a semester. Ruptured her spleen. It impacted her life in a horrific way. And all could have been avoided if the defendants would have just said 4 words. Give me your keys. Now, as my co-counsel explained earlier today, it's not enough for me to come up here as the plaintiff and tell you all the story. Okay, we, as the plaintiff, we bear the burden in today's case. We have to prove to you by preponderance of the evidence that there was a duty, that duty was breached, and that because of the breach, Ms. Chase got hurt. Now, preponderance of the evidence is pretty simple. It just means more likely than not. So your job as the jury to weigh the evidence, and if one side comes out, even if it's just by a little, that's the side you go with. And folks, we've proven our case. Now, I want to talk about the negligent action that we've alleged. Now, there's been a little bit of back and forth between whether or not we can be held liable if we served him while we knew he was intoxicated, or the defendants, sorry. But that's not actually what we've alleged. That's just the dram shop aspect of this case. What we're alleging is a general negligence claim, and you're going to hear this from the judge, but I wanted to focus in on it first. Now, it says you or a person who does something a reasonably careful person would not do under the circumstances is negligent. A person can also be negligent by failing to act. We are not alleging that the bar was negligent because they continued to serve Mr. Overton after he was drunk or after he was showing these signs. It's that they let him leave. They failed to adhere to their own policies, failed to add and provide their own employees with proper training to identify intoxicated people. They failed. That's what we're alleging. Now, they breached that duty by failing to take away his keys, by failing to keep a tab on Mr. Overton, by failing to recognize he was what he said he was, or what he was, intoxicated. Now, it's because of that, you're going to go back there and you're going to see a couple of questions. I want to walk them through really quick. Now, the first question you're going to see is this. Did the negligence of any of the below of those named approximately cause the occurrence in question? Remember, the jury, you saw the evidence. You heard from the witnesses. You know what the defendants knew that night when Mr. Overton left. Their own expert says there are signs that he was visibly intoxicated. That's enough to raise a suspicion. That's enough to take maybe a bit of care. But they didn't. They breached their duty, and because of that, the breach caused Ms. Chase to be injured. And that's why you're going to answer yes to Petunia Enterprises. And I want to talk about that second one really quick here, because the plaintiffs or the defendants, they came up here and they did something that, I'm going to be honest with y'all, infuriated me. They came up here and they tried to blame Miss Chase for her own accident. They tried to say because she had a couple of beers over the course of 5 hours, she was somehow driving drunk. And she got railroaded because of it. When you heard testimony that she wasn't swerving, she wasn't distracted, she wasn't even drunk. Somehow 5 to 6 beers over a 5-hour span is a whole lot of liquor, enough to make someone drunk while driving, but 5 to 6 shots or 6 to 8 shots over the span of an hour and a half, that's not enough to show someone's visibly intoxicated, according to their expert. That doesn't make sense. It's not reasonable to blame Miss Chase for what happened to her, to blame her for getting T-boned, coming down a street where she had a green light. It's not right. It's not fair, and it's what you should not do. It's why you write no. It's also why, if we flip the question too, and you apportion this liability, you're putting 100% of it on Petunia Enterprises. And 0% on Quinn Chase, because it was the actions of the defendant, not the actions of Miss Chase, that caused these injuries. It was what they failed to do, not what Miss Chase failed to do. She could have had nothing to drink that night, and this still would have occurred if she went out for that date. It doesn't matter, because they let it happen. Now earlier, my co-counsel, Mr. Buckley, told you that we'd be asking for damages in this case, which we are. Because we are, I want to walk them through. Now, this first one's going to be pretty simple. You heard Ms. Chase come up here and said that she was charged $75,000 for what happened to her at the hospital, or she was charged $75,000 for what happened at the hospital. That's why all you're going to award is $75,000. Nothing more. For physical pain sustained in the past, Ms. Chase suffered 4 horrible injuries. She suffered a concussion. She suffered a lacerated spleen. She broke her femur and she broke her collarbone. She was in a sling. She was in a cast. It was horrific. And for that, we're going to ask that you award $100,000 per injury. So for a total of $400,000. Now, for physical pain that Ms. Chase will sustain in the future, she told you, and she got a bit better. She recovered. But that pain, it's still there. That leg, it still hurts. That head, it still hurts. So we only think that it's fair that you take away from that physical pain sustained in the past and you award her half of that, $200,000, for those 2 injuries that are continuing to bother her in the future. Now, mental anguish is what we're going to talk about next. And you heard Ms. Chase come up here. You heard her testify that she was scared when this happened. That all of a sudden she was driving down a dark street one night, and out of nowhere, she's thrown sideways by a car that just T-boned her. She had to listen to that metal scrape. She had to witness and experience a traumatic accident. It's horrific. It weighed her. That's why we ask that you award $100,000 for that experience, that suffering that she had when she was T-boned. Next, let's talk about the mental anguish she's going to sustain in the future. Now, Ms. Chase is strong. She told you that. But folks, that laceration to her kidney, it did a lot more than just require emergency surgery. You heard her say that there's a probability she'll never be able to go outside free of mind again. Whenever she's out now, she's worried about getting an infection because her spleen, it can't handle it. Her immune system's potentially compromised. That peace of mind is gone. It's never coming back. We ask that you award the same, $100,000 for that loss of peace of mind. Let's flip over to the back. And if we go down a little bit, Mr. Buckley, pull the paper down. Now, there was a little bit of back and forth on the physical impairments that she suffered, but you heard about it. She was in a cast. She was in a sling. She was limited in what she could do and what she was able to accomplish. She had to take a semester off school. She couldn't hang out with her friends the same way. She couldn't even wash her hair the same way. So I think it's only fair that you award $100,000. And for this last one, we ask that you award 0. Because Ms. Chase is strong, and she told you that she's going to be okay from this physically. But mentally, that's still there. Members of the jury, if Quinn Chase could have one thing, it wouldn't be money. It'd be for this to never happen again. T-bone that night. I hate to break it to y'all, y'all aren't genius. Y'all can't grant wishes. Y'all can't make it to where this never happened again. All you can do is try to restore what Ms. Chase was before this. Only you 12 are the people that can give justice to what happened. You 12 are the only people that can make sure and send a message that this kind of stuff, these practices by these bars, it's not okay. Find them liable. Because they failed to say 4 simple words.
Sure. So may I constructively approach outside of the presence of the jury? Okay. So opposing counsel just misstated the complaint. They accused Montana Maxis of, if you look on page 3, count 1 under negligence, that the defendant number 18 knew or should have known that all actions visibly intoxicated. Number 19, despite the fact that the defendant knew or should have known that all was visibly intoxicated, defendant wished this to do in the following ways. And he just told the jury that they don't have to prove any of that. They just have to prove that he was unreasonable.
I'm gonna let you address it.
So is it okay if I publish it to the jury as I'm talking?
The petition?
Yeah. Okay.
administrative plea or evidence.
May I please the court? Inaccurate, incomplete, and irrational. That is the story that they've brought to you today. In reality, Mr. Overton was agitated, not visibly intoxicated. What really happened in the early morning of January 8, 2022, between the hours of midnight and around 1:32 a.m. Mr. Overton drinks around 4 to 5 watered down shots and a beer. At this time, the kitchen is still open. There's water available to all customers. Now, somewhere within that time frame, he throws up or he vomits because of bad food or a stomach ache. And then he gets into a fight with his friends because they accuse him of assaulting one of the servers. When the bouncers hear him arguing, they come over and try to get him to calm down. Instead of calming down, he starts arguing with the bouncers. And these bouncers, using their reliable trainings of true Q-tips, determine that Mr. Overton is not intoxicated. And so to prevent any more trouble, they ask him to leave. Agitated, he gets up and knocks over a tray full of drinks. And so they have to escort him out. Now he goes over to his car and spends about 20 to 25 minutes drinking a bottle of Bad Dog. At the same time, the plaintiff is in her car driving after 7 hours of nonstop partying, after drinking 4 to 5 beers and some scotch, on the phone with her date, talking to him. And then boom, the accident happened. Ladies and gentlemen of the jury, when the judge explains the law to you, you must remember that you promised not to let sympathy influence your decision. Rather, you must let the evidence or lack of evidence guide your verdict. The plaintiff had the burden to prove each and every element of their claim by the preponderance of the evidence. Now, opposing counsel stood up here and told you that he didn't need to prove that Montana Max's overserved a visibly intoxicated person, but that is incorrect. They brought Montana Max's today, claiming that Montana Max's overserved a visibly intoxicated Mr. Overton. That is why we're here today. They failed to meet this burden. Instead, they want you to believe that Mr. Overton was 21 years old, weighed 225 pounds at the time of the accident, was visibly intoxicated after having one watered down shot every 15 minutes for at most 90 minutes. Yet, they want you to believe that this plaintiff right here, who had 4 to 5 beers and some scotch, was okay to drive that early morning. That makes no sense. They brought you no evidence of Mr. Overton with bloodshot eyes, no evidence of Mr. Overton with slurred speech, a staggered walk, all of which are signs of intoxication under the law. Yet they brought you a defective breathalyzer. Now they claim that Mr. Overton vomited because he was intoxicated. Yet they cannot tell you at what time Mr. Overton vomited in that restaurant. He could have vomited after his first watered down drink, his second watered down drink, and so on. Dr. Malkin stood up there and told you that when someone vomits, some of the things that they drank could come out. And so they just did not provide any evidence pointing to the vomit as a sign of visible intoxication. The only person who mentioned anything about Mr. Overton stumbling at all in that restaurant that early morning is their supposed expert, someone who wasn't even there. Now, speaking of Mr. Crosby, when you heard him testify today, all that should have come to your mind was one word: biased. Mr. Crosby is here on behalf of Michigan Mike's. As you heard, he works for Michigan Mike's. Michigan Mike's is right across the street from Montana Max's. There are direct competitors. He's not just a regular employee, he is the general manager. And so if Montana Max's was to get in trouble and lose its business, then Michigan Mike's gains the business. That means more money in Mr. Crosby's pockets. He's not at all credible. Now, they came up here and said, "Give me your keys." They said that Montana Max's should have told Mr. Overton to give them his keys. Montana Max's had no rights to take away Mr. Overton's keys. They can't do that. The law does not require that. The law requires that they do not overserve a visibly intoxicated person in their restaurant. And so because they have failed to reach their burden today, because they have failed to prove to you that Montana Max's overserved a visibly intoxicated Mr. Overton by the preponderance of the evidence, or that he was even visibly intoxicated at all in that restaurant, then when you go back to the deliberation room, you'll be given a verdict form. And looking at question number 1, you put a no right next to Petunia Enterprises LLC. However, if you are inclined to find any fault at all in Montana Max's, even after everything that the evidence has shown, then we ask that you take into account the plaintiff's own actions in causing this accident. Members of the jury, unlike what opposing counsel said, we are not victim blaming. We are not disputing that the plaintiff was hurt, that this accident was unfortunate. Yet we are here for the truth. And the truth is, the plaintiff could have and should have avoided the accident. And that is where our burden as the defense comes in. We have the burden to prove that it was the plaintiff's own negligence that caused this accident by the preponderance of the evidence. And we've met this burden. The plaintiff sat up there and told you that when driving, it is important to remain alert at all times. Yet she admitted to you that before getting in her car and driving that early morning, she had been partying for 7 hours nonstop. She told you that it is important to remove all possible distractions when driving. Yet she admitted to you that she failed to put her phone on Do Not Disturb. And as she was driving, her date called her. She answered the phone, was talking to him when the accident happened. Finally, she told you that it is important to limit alcohol use before driving. Yet she had to admit to you that she had 45 beers and some scotch. She does not even remember at what time she stopped drinking that morning. Opposing counsel came up here and asked you to award the plaintiff more than $900,000. For what? I don't know how to answer that question. They don't have the answer for you. They were just throwing out random numbers, hoping that something would click. Because they have no evidence to support these numbers. They prove no evidence of past or future mental anguish. They told you, well, the plaintiff stood up there and told you, she talked about hockey. And she had to admit to you that she got concussions when playing hockey. She got headaches She had previous headaches before the accident, the same headaches that she has every now and then. She told you that she decided by herself to take a semester of school. No doctor asked her to do this. She stayed home and did nothing but play video games. She herself told you, and we wrote it down, I made the choice to go to summer school. And then when I asked her if anyone's told her that she would need any future treatment, she said, I didn't think that would be something they would tell me. There's no evidence of any of that. And so we ask that you return, and if you do get to that question, put a 0 on all options. But if you still feel inclined to give her something because you believe the evidence shows this, then we ask that you give $75,000. What actually had to be paid for her medical expenses related to the accident. But you must remember, ladies and gentlemen, that Mr. Overton is not the one seated at that table. He's not the defense today. And you might have noticed, but opposing counsel mistakenly called Mr. Petunia, Mr. Overton a couple of times. And I also made that mistake. I called him Mr. Overton. That is because we are all confused as to who should be sitting there. Because we all believe that Mr. Overton should be the one seated there. And so that is why the both of you are so important to this case. Because you get to render justice. You get to tell the plaintiff that Montana Maxis should not be at fault simply because Mr. Overton chose to be at that restaurant that early morning. You get to tell them that they have the wrong person, that this whole thing should have been between them and Mr. Overton. You get to tell them that Montana Maxis should not pay for something that they did not do. Find Petunia LLC not liable.
How much time we have for rebuttal?
3 minutes and 23 seconds.
I will not use it. Folks, the defense wants it both ways. They want the drinks Miss Petunia had that night to matter, but the drinks Mr. Overton didn't to not. They want to say they sympathize with Miss Petunia, yet blame her injuries on her own actions. They want to have safe policies and procedures that Montana Max had and followed, yet it doesn't matter that they didn't. I won't get away with that. I'll let them try to pull the wool over your eyes. Find them liable.
All right, thank you, Mr. Christie. The case is now for the jury to decide. As all the lawyers and the participants to step outside for a minute.
And so it was COVID. So
All right.
we had the best women. So,
I'll introduce myself. If y'all don't know who I am by now, you're not paying attention. I opted to, I thought about not letting over the phone around, two former judges on the panel. But considering how long some of the rounds went earlier today, I'm like, there is no way I'm letting this one go. Although I did confirm. But I'm gonna allow them to speak first, if y'all don't mind kindly introducing yourselves. I would say this before they introduce themselves, I'm very excited about this final panel. You have two former judges, Judge Barbara Stalter and Judge Scott Link. Barbara Stalter used to be a domestic violence judge, Judge Link used to be a civil district court judge. Judge Link was my advanced civil litigation professor at South Texas a million years ago.
Despite that, she's overcome that. And is a very good lawyer and a very good judge. So.
But I'm also very honored and flattered that we have Danny Franco, who's a third grad, Jordy Vargas, who's a recent South Texas grad, that they are here because not that any of our U of H alumni, they're all back to they've been judging up their tournament, but I find it meaningful. The students that I did not teach that I've gotten to know because of our respective martial art programs decided to devote and spend their Sunday afternoon to be with y'all, to judge y'all. And then you're fabulous too, I just mentioned you. Great. So I'm gonna let them talk first while I finish. So whoever wants to go first.
Judges first.
As Judge Weems said, I'm Barbara Stalter. I'm former judge of the 280th District Court, which is the dedicated family violence protective order court. It's the only court of its kind in the state of Texas. And it's a newer court. It's only been around since 2009. So I was the second elected judge. But I'm also a U of H grad, go Cougs. I did my undergrad and my at U of H. So the only reason why I didn't do mock trial was because it interfered with football season, and I'm not giving up watching my Chiefs win any game on any Sunday. So anyway, I want to compliment you all for the work that you did. I did not read the problem on purpose because I wanted to be able to see it as a real juror. And I think everybody did an amazing job. I'm going to give you one start at the very end with Ms. Blanche, and I'm going to tell you one thing I liked and one thing I'd like to see you improve on. One thing I liked is that you had your leading questions on cross-examination were directly on point. I like that. One thing I'd like to see you improve on is making sure that your presence before the jury is a little more polished. I felt that you were a little distracted. Okay. Other than that, you were really good. Miss Hannah, one thing that I really liked about you was that you had a very confident demeanor when you stood. You were very articulate, and you made very good eye contact with the jury. One thing I'd like to see you improve upon is maybe when you're asking questions is to use your voice just a little bit more to drive your point home when it's something that you want the jury to be impressed about, or something you want them in your cross-examination, you want them to be able to specifically take note of. Okay. Gunnar, dude, you're amazing. I really do not have anything negative to say about you. I wish I did. I wish I could think of something.
Most people wish. Yeah, most people.
I don't. I literally saw you as a trial attorney. Dude, I don't know what to say, but good job. Just keep doing what you're doing. George, I also thought you had a very good demeanor. I thought your opening was very good. You gave me a very good roadmap. I appreciated that very much. The one thing I would like you to work on is in your direct examination is to use more open-ended questions. The who, what, where, when, why, and how, because you want the story to come from the witness. You don't want the story to come from you. Okay? Good. Witnesses, I think you all did amazing. I'm not going to give you any specific pointers other than some of you at the very end lost me when when you went to arguing with the attorneys, and sometimes that's not going to win you points with the jury. Some of you were a little bit over helpful on the demonstratives. Let the attorney guide you. Let the attorney tell you where they need you to go. You don't want to look like you're the one who is the attorney in the case. And I felt sometimes that went a little beyond that. Other than that, team's great. Thank you.
All my notes are on the ballot, so
Do you need it back?
do you mind?
No. Why don't you let somebody else?
Yeah, somebody else can go. and
Yeah, absolutely. Hello. First and foremost, I'm not really important, y'all are, but briefly, Daniel Franco, criminal defense attorney primarily with some other associated areas of practice. Previously clerked for the 13th Court of Appeal, so a little bit of some appellate experience, and now we're here in the trial courtroom doing all of the things y'all are doing. I just want to congratulate you. You're doing something very, very difficult. There is attorneys, and then there are trial attorneys. And to be in that second echelon of attorneys distinguishes you greatly from everyone else who is a practicing attorney. So I have nothing but kudos for everybody here, witnesses included. Y'all did phenomenal. I'm not going to take any more of your time than I need to. So I'm going to start with a global criticism, and then I'll go down the line and we'll wrap this up. Globally, we need to be better about leading in the appropriate areas. If you are, and this is also with a grain of salt, the GOAT is right there on the bench. So take this not as gospel, but just as a suggestion. If you are on leading, you should not be asking questions that you, one, don't know the answer to, or two, only in rare exceptions, you don't care what the answer is. So if I hear how or what, or can you explain that, an open-ended question on cross-examination, you're gonna get yourself into some trouble. And Mr. Osteen, correct? You were great, my guy. That's where you got into trouble on your cross. So I'm not too much of a fan of the arguing on cross-examination. I think the witness did what he was supposed to do, kind of throw you off your game. Practicing some witness control in that regard would be great. I'm sure Judge Wings can give you the hierarchy of what you should be doing there, but that would be the only criticism I would have for you on a cross-exam. Other than that, you were stellar, my guy. Mr. Buckley, I heard that you were a 2L. Great work, sir. Love the opening statement. You gave me a roadmap, but again, globally, the open-ended questions on leading, man, the witness is gonna run, man. Okay, so just sharpen that up. Ladies, you were both phenomenal. Felt at times like we got a little bit discombobulated with the direction in which we were headed in, primarily on the direct examinations. I'll just kind of backpack with what Judge Barber said. Who, what, when, where, why, how. I'm gonna add 2 more into that. Explain, describe, okay? Everything open-ended. And Ms. Dutu, I like the awareness. You had like your little radar going with some, I think I caught the drinking time on your cross-examination, familiar with the parking lot, and then the left arm discrepancy were 3 instances in which you signaled like you were about to impeach the witness. I will caution you, sometimes there's collateral impeachments, which aren't really gonna help us much. And I think Mr. Osteen did a great, or I think it was you, Mr. Buckley, correct me if I'm wrong, calling out that there was like an improper impeachment. These things can go either way, but just having the awareness that it has to be a material fact. It has to be something that really turns the tide in your favor, that they either omitted from their prior testimony or straight up inconsistent with what they said previously. That would be the best way to go. And if they say, you know what, I don't remember, you have a tool for that too, okay? And then I have a question. Quinn Chase, ma'am, I'm sorry for your injuries. Is there an argument that she caused them herself also? Is that where the defense was kind of coming from? She was contributorily negligent? Okay. That demonstrative would have been a perfect opportunity to flip on the plaintiffs and say, hey, you know, out of curiosity, someone else was drinking too, right? From 5 to 12, and then start creating a timeline on their own demonstrative, highlighting how she was also drunk at midnight when your guy started allegedly drinking. She would have had exponentially more time to become intoxicated as compared to him. So be mindful that sometimes there are ways to incorporate what the other team has done to flip for you. That shows advocacy 101. That would help you get some more points. Summarily, y'all, that's all that I have for you. Great work, very proud, and thank you for having me.
Just that there?
Yeah. Yes, that's it.
First of all, what you're doing is very good. It's very helpful. If you intend to try lawsuits when you graduate and pass the bar exam, this is a very good first stepping stone to doing that, because I will tell you, it is a It's an art. It takes a while to develop. And don't copy somebody because there's some very good lawyers out there. And don't try to go down to the courthouse, watch them. Judge Williams will tell you when she's got some good lawyers in her court. Come down here, spend a couple hours watching. And you'll see good lawyers doing good work on their trade. Also, when you use a deposition, ask the court to explain to the jury what a deposition is. The fact that, if I was a juror, I don't know what a deposition is, I don't know what he's reading from. It's something that's under oath, gives the same weight and credibility as if someone were testifying live from the witnessing. Also echo lead. Always, isn't it true? Start off that. Don't give them a chance. Don't ask the expert to explain. This is your expert. Isn't it true? And then just and go from there. You used the term, plaintiffs used the term she broke. She didn't break anything. He broke. The accident caused a broken leg. My client sustained because of the accident a broken leg. So she didn't break anything. Also, you didn't really get in that much to the damages on pain and suffering and mental anguish. Mental anguish is more than just day-to-day worry. Mental anguish is a deep concern. And I just sort of didn't get that, but that's okay. I mean, and so you really want to, really sort of extrapolate on that. And her concern is, for a while, what am I going to do? I got a broken leg. I'm pain and suffering. And how did it feel when your collarbone fractured? How did it feel when your leg snapped in two? Use words like that that's just so descriptive. Snapped into, crushing sound and feel of your collarbone, stuff like that. Those are buzzwords that people can empathize with. And that's where you get your damages. So it's a deep concern, and I really didn't get that too much, but that's okay. You're what, 2 L's? I mean, when I was 2 L's working and drinking beer. And going to school.
They do that too, I promise you.
Yeah. No, they're doing more than that. I just drank and went to school and worked. So this is really a good start, and you guys are incredible for 2 L's, better than some lawyers I had come to my court. So stay with it, don't give up, and don't be afraid to go down to the courthouse when Judge Williams has some good feedback. But I think everybody did a very good job, and you ought to be commended for, you could have been doing all sorts of stuff, pursuing your hedonistic pleasures. Instead, you're putting a lot of hard work on this. And I'll tell you, before Judge Williams, my class was what, 5:30 to 7 on a Friday
5
night?
to 7 every Friday.
Friday night at 5 to 7. How interested do you think they were on learning trial ad? I mean, every night I would say, I know you're interested out here to pursue your hedonistic desires, but bear with me. And so.
It was pretty horrible. And they only offered one section, and they were always 5 to 7.
5 to 7 on Friday night.
5 to 7 on Friday.
So I have some other notes here, but that's kind of it. I think the damages were kind of high without explanation, but having broken several bones, I would say, man, it's painful. So you need to kind of go into that. How did it feel when your leg snapped into, and the crushing of your collarbone? It was just unbelievably painful, like tears to my eyes. I mean, stuff like that. So that's kind of it.
Hey, Kaylee, why didn't you crawl on the stand?
Yeah.
If I could have, I'm sorry. It's also so late in the day, guys. I don't think I have enough water in me to cry right now.
anyway, that's it.
Thank you.
I'll go next. My name is Jordy Vargas. Like Judge Williams was saying, we met. She didn't coach me, but we met at one of the tournaments. I did mock trial all of undergrad, all of law school, and I'm a personal injury attorney at Abraham Watkins. So I'm learning from the best and trying to stay in the loop on stuff. I got comments for each of you individually. I'll keep it super, super short and quick. Just like overview stuff. Three things. One, be organized. Whether that's setting up the well, setting up demos, setting up whatever, be organized, be smooth with it. A lot of mock trial is presentation. So if you're pulling up an exhibit, have it ready to go, know exactly what's going on, how it looks for the jury. Number two is listen, especially on cross, right? You might get something from the witness that's pure gold, but it might take you a little bit away from the script. Don't be scared to run down that. Stuff like that, right? Like be a president around. The last thing I'll say is kind of find your voice. I know, especially as a 2L, I don't know if this is your first experience with mock trial or anything, but a lot of the times doing mock, you want to do the lawyer talk and you want to sound like a lawyer, but you don't really have to. There's a good balance between how you want to sound and what sounds good as as a lawyer or whatever. And I think that's really important because it comes across as authentic, and the jury really likes that. So, like I said, I got individual stuff. Y'all want to come up and chat, but generally, great job for all of you.
Hi, my name is Sadi. My last name is Anton Matei. I'm with the Kirk Garcia Law Firm. I currently do personal injury plaintiffs litigation, but for most of my life, I've done defense. So I try to use everything I've learned my previous years of defense work to use now to the benefit of my clients. So I guess I had a little bit more things to think about the defense strategy more than the plaintiff strategy. Everybody that's spoken to me, I have said everything that I actually agree with. I also do have a bit of pointers on the plaintiff side. You guys are always going to be taught by David Ball and all these books that you're going to read that you have to show a clear rule, a violation of the rule, and the results of that violation. And I think y'all's opening needed to be a little bit more cleaner. And don't just tell us, show. You have to use visuals as much as you can without taking away from the content of your message. But I usually use PowerPoints. I use overheads. I use whiteout boards that you can expand. So keep it fluid, but it's always better. You guys afterwards started using the Elmo, and that's something that burns into the minds of your audience, because you always have to watch out for your audience. Don't go through an outline just thinking you're just checking boxes. Okay, cool. I hit that box. But rather, think of your audience. They don't know anything about your case, so your story has to be tailored to somebody that's listening to this for the first time. You guys have been living with this 5-6 weeks, this problem. So you have it all, a little bit of bias of what you guys know, but we don't. And I think that happened in Ms. Chase's direct. You were doing a great use, George, of open-ended questions to tell the story. But like Judge Link said, we need a little bit more. If you want to sustain those damages, you have to have a little bit more. But the use of the open-ended questions was awesome. I don't think you hit the concussion though in her direct. And then for the defense, you already had a plan to discredit the concussion, and you didn't pick up on the fact that they didn't bring it in direct, and you should have just let it go, right? And maybe you could have addressed it in a motion in limine at first, because they didn't have any expert testimony, or at least a stipulation that I saw about concussions, broken bone. Those are things like lay jurors can go into, but something when we're talking about discography, concussion, or something more of that nature, you're gonna need some expert testimony to establish these damages, and the plaintiffs didn't have it in this case, as far as I'm aware from the reading of the material that I did yesterday and today. I agree with the impeachment issue. It seemed like you were chasing that aha moment, but I don't think you ever got there. So it is something that has to be it truly has to be an For the defense, I would say some of your work is reactive, like I didn't say concussion, so we don't go with concussion. But the defense in its entirety cannot just be a reaction to the plaintiff's case. I think that a good defense attorney is always going to have their story, that defense story. It's not, well, this is plaintiff's story and we have to live in it and react to it and play in their field. So I think you guys needed to devise a strategy that was your message rather than just reacting to the plaintiff's message. Like, for example, the agitation defense, I know what you were going for, but I thought that may be a little bit more scientific, going into the BAC charts and the time. You did hit it with your expert. Your expert, by the way, guy, man, you were doing a great job until you got a little bit defensive with counsel. But I thought you guys were going into the issue of, hey, if you can't prove he was intoxicated, how could you prove he was visibly intoxicated? So if one thing's 0.08 and the other one's 0.15, and that's what he's testifying, well, if you can't prove one, how can you prove the other? I also don't think the plaintiffs brought up the breathalyzer, but you guys did. And at that moment when you brought it, I thought it actually hurt you more than it hurt them. So I think those are the kind of things like you gotta adjust on the fly. But honestly, defense work is you guys. I think the plaintiff already has it hard because they have to bring up not just the burden, but they have to create a case. The defense is usually just shooting it down, but you also have to know they didn't put any target. You don't have to shoot anyone. So a little bit of restraint there will help you guys. The leading questions. You need all four of you need to have a little bit more control of the leading question. It's a statement. What you want is a statement, and true, and you always want it to be true. It's your words in the witness's mouth, and they agree. And you're going to do that based on evidence that you can easily prove, or is stipulated, can't lie about it. Or like Danny said, you don't care. I mean, if they say something else, it doesn't matter. It's just ridiculous that they say something else. And then the answers, especially experts. You're gonna, once you guys graduate, you get your law license, you're gonna see experts. I think both experts did a freaking great job in doing the expert thing. You ask one thing, they say what? They have a narrative, and they always want to push that expert narrative. So when cross-examining a witness, an expert witness, you have to have a lot more tighter leading outline and not let them give you their BS message. Other than that, I mean, I also have some stuff here, I think. Yeah, the organization. I mean, I lost the case May last year. I was 150% sure I was getting a continuance. I didn't. I had to try it on the fly. I had a mess in my desk. Jurors told me, man, what the heck were you doing? So the organization is always going to be key. He who wins or she who wins the case is whoever is better organized and knows the case better than the other party. Outwork your opponent always. Man, thank you for the opportunity to be here.
All right, so before we announce the winners, we're gonna take a group photo first. So we announce the winners already, the winner first. I'm gonna want to first.
Mr.
Can we all judge it down?
My son-in-law.
Small world.
Me too.
Yes.
Would you like some? I can take the photo.
Sorry, forms are done.
Oh.
Yeah.
Don't be looking at me.
I don't know, it's sorry, it might be. This guy, fucking read my notes.
Yeah, let's put all the judges, one big group photo with all the judges. I was
I don't even know, I don't care.
They go like each other.
I got a 4-5 teach for our, that would be for this.
Thank you. So.
Should I bring them?
Touch it.
All right. All right. So we're going to listen out the outstanding witness. The outstanding witness for the 5th annual VLG is you, Kayla. See, much more interesting than a flag. The outstanding attorney for the. Yes. Solo attack. I'm going too close to you. She's gonna say right. It might stick to your foot. Not that it affects the verdict, there is actually a finding of liability. The average across all 5 ballots, $580,000. So good job. And 49 footer, I would say, to me, this was a lot of fun to watch because last year in the final round of the VLG, Jenner and Blonde partners. And so they won it. So it does not surprise me that you guys are both here, even though on separate teams this year. I'm very proud of all of you all. But the winning team of the 5th annual is up according to convening is it's just engineers.
Yeah.
That was so fun. Good job, guys.
And then we're gonna take a picture of the winning team real quick.
Oh, no, you're okay, no.